dismissing the application filed by the husband. Husband filed an application. Do you want to work on section 30?
Who raised the point of jurisdiction?
Your Lordship, Learned Court.
Learned Court. As per section 37 of Special Marriage Act, my lord.
1 minute, please wait. Where is the paternal home of the petitioner number 1?
Petitioner number 1, Birbhum.
Where how have you read the show me the
Page number 20.
application.
My lord, page number 27, it is written on the third para. My lord.
Wait a minute.
Yes, my lord. The last recited, third para. After the solemnization of marriage, wife petitioner number 1, husband petitioner number 2
Where
stated.
was the marriage solemnized?
14th August. 14th.
Where?
2009. Canal Street.
Canal Street.
Canal Street. After the marriage, both the parties have resided there at Canal Street, PS Entirely.
My lord, the petitioner was doing a job in Salt Lake.
In Canal Street.
Canal Street.
Yes, my
Yes. My lord, without considering that.
What is the jurisdiction under the Special Marriage Act?
As per section 31, my lord,
31, 3.
address to be considered as per clause 2, the respondent at the time of presentation of the petition resides, and clause 3, the parties to the marriage last resided together.
Then?
Last resided together at
Let's
the
take down.
PS Entirely. I have the original Aadhaar card also.
Give me the jurisdiction.
Jurisdiction, your lord. I have also made a copy, your lordship. For
Okay, now. The revisional application has been filed challenging an order dated December 8, 2020.
second page, your lordship.
Passed in matter number 89 of 20.
Shialda Civil and Criminal. Entirely is the first police station. Entirely Narkeldanga Maniktola.
By the said order, the Learned Court.
I'm presenting a copy.
What is section 40?
Section 40 is, my lord, application of
Came to
Act
the
5 of
finding that the parties had not presented the petition before the
power to
appropriate
transfer
district
petition
court.
to certain cases. That is section 40, my lord.
Having power to
Transfer the case.
having ordinary original civil jurisdiction with regard to the to hear the matrimonial suit, to try the matrimonial suit. According to the Learned Court, the petitioner had failed to show any document indicating the petitioner number 1. Who is petitioner number 1?
Petition number 1.
Husband.
Yes.
You're the petitioner here also.
Yes.
The petitioner husband, number 1 Ligana, was not able to show the address in which he was last residing at the date on the date of presentation of the petition, or where both parties lastly resided. Stop. In other words, the court came to the finding that there was nothing on record to show that the husband had been residing within the jurisdiction of the Shialda court. That is the finding?
Husband and wife, husband or
Husband
wife.
and I,
It's the
we
finding.
yes, finding of the court here.
The finding. Both the learned advocates appearing for the husband and wife submit that the Shialda court has the jurisdiction to hear the matter, as the pleadings would indicate that the parties last resided together at husband and wife at 3 Canal Street, North Block, 4th floor, flat number 4A, Kolkata 7,14,000. It হচ্ছে paragraph 3, page 27. দেখে নেবেন. The documents which have been produced before this court, namely the Aadhaar card and
Original Aadhaar
anything?
card.
Your Lordship, my address is in Birbhum, Your Lordship, and we lastly resided on that.
Namely the Aadhaar card of the wife.
Wife.
This is the Aadhaar card. Original Aadhaar
Because
card.
my workplace in Salt Lake.
That the husband and wife lastly resided at the paternal house of the wife
Yes.
seem to be correct. The Aadhaar card of the husband of the wife has been produced with the said address. The jurisdiction of South 24 Parganas has the territorial jurisdiction of the courts in respect of the district of South 24 Parganas has been produced before the court. It appears that where are we? Wait, Anna. Yours is which police station?
Entirely, my lord. Entirely.
So police station Ental territorial jurisdiction, Uttradanga, Kashipur, Ental, yes. Which indicates that
Page number 18 also says.
Entally is under the territorial jurisdiction of Shialda court. Hence, the order impugned is set aside. The learned court below is directed to proceed with the matrimonial suit number 89 of 2022 expeditiously and dispose of the same within the next 6 months.
My lord,
can it
only
be
one prayer.
2
6 months cooling period has already lapsed. My lord.
left?
It was 5 July 2022.
Next 3 months.
Deeply obliged.
Deeply obliged.
Yes, next matter.
My lord, I am appearing for the petition.
Lord, I beg to appear on behalf of the opposite party led by Mr. Tulsi Dasmai.
এখানে কি হচ্ছে? যাই হোক। হ্যাঁ।
82D. My lord, the revisional application, my lord, arises out of an order
To be
rejecting.
mentioned?
My lord, to be mentioned, my learned friend has agreed to the extent that the order be
Oh,
set
this
aside.
Yes, sir.
was
Yes.
mentioned.
Order be set aside and my lord, expeditious hearing of the commission. My lord, the application.
All right. Let me see. This revisional application has been filed. I will not record your concession. That is what you're saying. Date, filed against an order dated May 2, 2023, passed by the learned Civil Judge Junior Division. আচ্ছা, ওটা কোন order date আর কি ওটা একটু লিখে দেবেন কি, হ্যাঁ? Civil Judge Junior Division Additional Court, Sirampur, entitled suit number 173 of 2015. By the order impugned, the learned court below rejected an application
Under order,
for under
Order
order
26, Rule 1.
1 of the Code of read with, sorry, Order 26 Rule 1 read with section 151 of the Code of Civil Procedure. The said application was filed by the
by the
by the
defendant.
defendant, ma'am.
by the defendant for evidence on commission.
Commission.
Evidence on commission for her examination on.
Yes. The defendant prayed that an advocate commissioner be appointed to examine the defendant at her residence on commission on the ground of ill health.
She is bedridden.
A prescription of one Dr. Kollan K. Palit dated April 23, 2023 was also filed. The contention of the defendant was that she was paralytic. She was a paralytic patient and was completely bedridden. She was unable to attend the court to depose in support of the defense case. The defendant was also ready to bear the cost of commission. The learned court rejected the said application on the ground that the suit has been pending for 8 years. The evidence of the plaintiff was closed on March 27, 2023. Thereafter, on April 17, 2023 was fixed for DW, but the defendant filed an adjournment and the next date was fixed on May 2, 2023. On previous occasions, the defendant had not mentioned about the illness. The learned court thus did not accept the contention of the defendant being paralytic and unable to depose in court, as the medical certificate did not indicate whether the defendant was permanently or temporarily rendered invalid. No, rendered was whether the the defendant was permanently now whether the condition of the petitioner was permanent or not. The learned court proceeded on the assumption that whether the defendant was able to understand the implications of deposing or whether she was able to speak or not would be relevant factors. A mere certificate from the doctor would not suffice. Hence, the application for examination on commission was rejected. What have you got to show? Why read here? I will pass orders from here. I'll allow it.
Hello. Would your lordship be kind enough? Yes, my lord. This is a
On one
suit of,
chief and cross will be done.
because this
Chief
is a
and
suit
cross
of
day, 1 day,
2015.
my lord, within a month.
No.
Within a month
No.
from the date of, my lord, appointment of the commissioner.
Yes, all right. But only on 2 days it will be allowed.
Allowed.
1 day chief, 1 day cross. Within a month, that whole process. But only 2 days. And you will bear the cost.
Yes.
Where is the Mr. Mitro? Show me the document of your illness.
My lord, that I have supplementary affidavit. I have this annexed to the certificate, and my lord, also with the revisional applications, my lord. I have given certificate, my lord, in course of hearing of the suit, my lord. This was given to the was placed before
Yes.
the learned court.
In my view, the learned the doctor, who is treating the defendant has categorically stated that the defendant was bedridden due to hemiplegia. স্পেলিংটা একটু দেখে নিতে হবে। হেমিপ্লেজিয়া স্পেলিং হচ্ছে right side hemiplegia. Now, due to hemiplegia suffered on the right side of the body, as a result of which she was not even able to sign. Whether the requirement as mentioned by the learned court below as to certification whether the petitioner was able to speak or whether the petitioner was able to understand the consequences are not relevant. The revisional application is thus allowed. The learned court below is directed to pass necessary orders by appointing a learned advocate commissioner who shall examine the defendant on commission. The cross-examination shall also be on commission. The commission will take place at the residence of the defendant. The examination in chief and cross shall be completed within 2 days, 2 consecutive days, as fixed by the learned court below. The entire exercise shall be, learned commissioner shall file report as per direction of the file. The entire exercise as directed above shall be completed within a month from date of communication of this order. The suit shall proceed expeditiously and be disposed of within 3 months from completion of the commission.
Much of it.
This court has not gone into the merits of the issues involved with the suit.
But may I make one humble?
Yes.
The parties have to
Urgent.
act on the basis of
Server
হ্যাঁ,
code.
parties to act on server copy আর একটা urgent photostat copy ও দিয়ে দেবেন।
much of
All
it.
right, disposed of. Yes, please.
But only after your lordship's intervention, my lord, the matter has been disposed of on the last day itself, my lord. No further directions are required in the matter. my lord.
Yes. Mr. Agarwal has produced the order dated July 7, 2023, issued by the learned additional district judge, second court, Sirampur, Hooghly. It appears that matrimonial suit number 465 of 2022 has been disposed of, and the marital tie between the parties has been dissolved by a decree of divorce on mutual consent under section 28 of the Special Marriage Act 1954. Now, nothing survives for a further decision in the revisional application. The revisional application is accordingly disposed of.
Extremely good.
Next.
Lord, I am for the petition, my lord. I'm for the petition, my lord. Affidavit service misplaced, my lord.
Serve again and come back. I'm
Yeah.
not extending the interim
My
order.
lord, fix any day, my lord, subject to your convenience, my lord.
Monthly list of August, serve and come. 2 weeks you need.
Fix any date, my lord, hearing date, my lord. It will
Why
be-
should I? It's at your pleasure.
No, no,
My
no, no,
service
no,
is
no, no,
fix
my,
any day.
no, my lord, I have served.
Talk to a court.
No, my lord, I served twice.
যা বলেছি
Served
তাই
twice.
হবে। As the affidavit of service is not ready, there is no question of extension of the interim order. Let this matter appear in the fresh service upon the opposite party. How many parties are there?
Only one.
Opposite party, affidavit of service to be filed on the next day. Let the matter appear under the heading extension of interim order in the monthly list of August.
Great.
করবে তারপরে সার্ভিস থাকবে না মানে যা ইচ্ছা তাই শুরু আছে।
I am for the petition.
Yes.
on
Sir,
the
I am
last
appearing
day.
on behalf of the opposite party, my lord.
Last-
My lord, they have listed the mentioned the matter, my lord, without serving any notice upon me. My lord, I can able to contact with
Sir
my client.
Kali, you have been in the appellate side for how many years?
Under difficulty,
On the last day,
instruction is necessary, my lord.
on the last day, my lord,
All right, all
it was pointed out that my lord, the sum of the defendants was not.
Yes, yes, Mr. Ghosh is there.
My lord, on the last occasion, my lord, it was pointed out that the defendants were. So this is my lord, by the proposed added party is the petitioner before your lordship. Addition is being rejected, but by mistake, my lord, the defendants was not made party in the revisional application. My lord, this is the affidavit of service. Can one is for my lord adding those defendants.
So have you served those
Yes, yes,
defendants?
yes. That was.
Can koi?
Can one my lord only for
Ashadi, there, give me a copy. Mr. Ghosh, you have can one?
Just now it has been served.
Yeah, that's-
লিখে দিন একবার দিন 10 সাহেবকে একবার দেখাই আমি দিয়ে দিচ্ছি আমি।
So in the civil division,
In the civil revision, my lord, if your lordship takes up my lord the plaint is at page 13 of my lord's brief.
1 minute, please. Plaint is at page
13
13, yes.
Now my lord, the
Oh.
plaintiff is the principal my lord opposite party. He is there, he has been added, but by mistake defendant number 1 to 20 was not being added
In
in the
the,
revisional application.
oh, all
That's-
right. That's
No,
correct.
that reason, my lord,
Actually,
yes,
yes.
to that, my lord, I have no objection. my lord.
Plaintiff is my lord the actual
Let me
opposite party.
first allow the can one. Acha, can one of 2023 is an application under order 1 rule 10 of the code of civil procedure for adding
Defendant number 1 to 20.
the defendant numbers 2 to 20.
2 to 20.
1 to you have
Otim-
added.
Yes, yes, Otim touch.
2 to 20 in the revisional application means CO number 3136 of 2022, which according to the learned advocate for the petitioner was left out by mistake. On account of the fact that this mistake is bona fide and not intentionally done to obtain some benefit by leaving out the defendants, this court is of the view that the said application must be allowed. Oh, তার আগে লেখো can one এর ওই জায়গাটা একটা rider করে দাও। Can one কি বললাম তো? The original copy of the can cannot be traced in view of the change in determination and the courts. Hence, Mr. Mukherjee is allowed to file a photocopy of the said application before this produce. And the same is taken up on consent of the parties treated to be a true copy of the original. করে তারপরে হ্যাঁ আচ্ছা ওটা ফাইন্ড আউট করে ট্যাগ করতে বলে অফিস ইজ ডিরেক্টেড টু ট্যাগ দ্য রেকর্ডস ক্যান ওয়ান তারপরে in view of disposal of can 1 of 2023 the defendant numbers from Shudhin Kumar
Sudhin to Rocky Bera.
the where have you pleaded in her the opposite parties oblique defendant numbers 2 to 20 be added in the array of opposite parties as stated in paragraph 3 of the can. Tarpore can allowed. Office is directed to take steps. Yes. CEO.
No, no, Josh
But
had made.
Now, if your lordship takes up like page 13,
Hmm.
my lord, the
একটু বসুন, দেখি।
plaintiff's case is that
Your addition of party was rejected. Why?
yes, yes. But now
The application when the petitions claim to be an interested party of as part of the suit land which was transferred by Pune in favor of them by virtue of it was later transferred by
It's basically, my lord, on the principle of dominus litis. Why, my lord, this will not apply, my lord? I shall show, my lord, two documents. Yes, my lord.
One relying on
No,
order 22.
No, not that. Kindly takes up, my lord, once the prayer, my lord, at page 18.
What is the plain case?
Yes, my lord. Kindly takes up, my lord, once page 18. My lord, the plain case is not at all. Now, my lord, it's necessary. Why, my lord? The prayer will suffice. Kindly takes up page 18. Nalishi ko toposhil.
80.
My lord, 18.
18.
My lord, it's a continuation of the plain.
Yes, all right.
Yes. My lord, prayer ক নালিশি ক তপশীল সম্পত্তি বাদীর সত্ত্বীয় সম্পত্তি থাকা ও উক্ত ক তপশীল সম্পত্তিতে বিবাদীগণের বিন্দুমাত্র সত্ত্ব না থাকা প্রচার করা। বিবাদীগণ যাহাতে নালিশি ক তপশীল সম্পত্তিতে বাদীর শান্তিপূর্ণ দখলে বিন্দুমাত্র বাধাবিঘ্ন সৃষ্টি করতে না পারে তজ্জন্য তন্মর্মে বিবাদীগণের বিরুদ্ধে চিরস্থায়ী নিষেধাজ্ঞা। Not alternatively, it has also been prayed, not the share of the plaintiff. Lord, kindly turns over the page, Lord, your lordship will get the cost schedule property. The plot number is 102 by 402. It's a Bata plot, my lord.
Where is it?
My lord, cost nalishi ko toposhil সম্পত্তি, my lord, the schedule. Second line of the schedule, your lordship will get, my lord, after jail number.
Yes, Bata plot.
Yes, this Bata plot, my lord, according to the plaintiff, is containing 114 decimal, out of which he is claiming, my lord, that is the fraction of share that has been mentioned, my lord, entire topshil, my lord, that is, my lord, prayer schedule C, D, E up to, my lord, your lordship will get, my lord, the same dark number. Now, my lord, if your lordship turns over to page 21, your lordship will get, my lord, the principal defendant have not only filed written statement, but along with counterclaim. What prayer they have made, my lord, if your lordship kindly turns over to page 30. Here also, my lord, the defendant, in respect of the self-same plot, claiming, my lord, their exclusive right, title, and interest, and alternatively also, my lord, the fraction of share. My lord, your lordship will get, my lord, the page 34, the same plot number.
Now,
my lord, if your lordship turns over to my application under order 1, rule 10,
that is?
my lord, that is at page 35.
Yes, দরখাস্তকারী শ্রীমতী সোহেনসু দরখাস্তকারী
বিনীত নিবেদন এই যে নালিশি 102 by 402 দাগের সাচ এন্ড সাচ জমির পূর্বে সাচ এন্ড সাচ দাসীর 1/2 অংশে সত্ত্বীয় দখলি সম্পত্তি ছিল, তদ্রূপ তাদের নামিত 33-36 সালের জরিপের রেকর্ড চূড়ান্ত প্রচারিত হইয়াছে। ভগবতী দাসী নালিশি দাগের 57 ডেসিমাল ভূমি আমলনামা মূল্যে দখল দিয়া ও সেলামি লইয়া খাজনা ধার্য করিয়া অনন্ত নন্দকে বন্দোবস্ত দিয়েছিল। পরবর্তীকালে ভগবতী দাসীর ওয়ারিশ শারদাময়ী মণ্ডল ও তাহার অন্তে পূর্ণেন্দু মণ্ডল তাহা প্রাপ্ত হইয়া পূর্বের আমলনামা স্বীকারে ইংরাজি 4/7/1914 তারিখের সাচ এন্ড সাচ বিক্রয় কবলা দলিল মূলে অনন্ত নন্দকে বিক্রয় করিয়াছিল। পরবর্তীকালে অনন্ত নন্দ তাহাতে সত্যবান এবং দখলদার থাকাকালীন ইংরাজি 19/3/1916 তারিখের সাচ এন্ড সাচ দানপত্র দলিল মূলে অধীন দরখাস্তকারীকে দান করিয়া সত্ত্ব দখল প্রদান করেন। তৎপর হইতে দরখাস্তকারী নালিশি দাগের 57 ডেসিমাল ভূমিতে সত্যবান ও দখলিকার আছে। So, my lord, up to this, what I anticipated that there are rival claim of title in respect of the same plot, where, my lord, I have also, my lord, share in respect of the property, that is for 57. Lord, I will show my deed immediately thereafter. I shall
No,
take
what have you said? The দরখাস্ত
কারী নালিশি দাগে 57 ডেসিমাল ভূমিতে সত্যবান ও দখলিকার আছে by virtue of, my lord, the deed dated 19th of March 2016
So in which
from
plot?
Ananto
Same
Nanda.
Bata plot?
Same.
Same
Lord, I
Bata
shall
plot?
show before your lordship. Kindly takes up page 43 once, my deed.
Yes.
My lord, the schedule your lordship will get 102 by 402.
দাঁড়া 43, page 43, where is that?
My lord, page 43, internal page 6 of the deed, my lord, after the topshil, my lord, your lordship will get দানকৃত সম্পত্তি such and such. Now the বন্ধপুকুর
14.250 decimal.
Yes, my lord, this is fraction, my lord.
ভগবতী শ্রমিক 250 বুলা কোথায় গেল?
My lord, the just my lord, 102 by 402, my lord, your lordship will get, my lord, nearing this portion. Has your lordship got it, my lord?
Pukur.
Yes. My lord, the schedule are there. My lord, entirety I will, from this deed, my lord, I will get, my lord, 57 decimals. So, my lord, what I anticipated that there will be a threat to my title since I am also a co-sharer in respect of the property. Now, kindly turns over their written objection. I will rely on that only. Kindly once takes up, my lord, the plaintiff's written objection to my application for addition. That starts with page 49. I will not trouble your lordship. Kindly take.
They asked for how many decimals, Mr. Ghosh's client?
Yes, they ask for, my lord. They ask, my lord, several, my lord, your lordship, kindly tally with page 19 and 20.
88 decimals of land, my lord.
I will show. My lord,
You are
file.
claiming 88 decimal, the
Yes.
defendant is
And-
claiming by counter claim how many
Well,
decimals?
let Mr. Mukherjee submit, my lord, then I shall make him that.
Yes, yes.
Now, my lord, if your lordship turns over to page 49, that is the plaintiff's written objection to my application for addition. Why I will say, my lord, this is important. Kindly turns over to page 53. What is their positive statement? Because I am claiming from Nando, Ananto Nando, my title. I have traced out my title in my addition of parties application. Kindly turns over the page 53. My lord, nearing, my lord, 4 to 5 line from the top, Prokito Pokhe উপরিউক্ত, yes, উপরিউক্ত বিক্রয় কোবালা নামধেয় দলিল ও মূলে নালিশি সম্পত্তিতে অনন্ত নন্দের বিন্দু মাত্র সত্য দখলের উদ্ভব হয় নাই উক্ত such and such নম্বর বিক্রয় কোবালা, by virtue of which I am claiming title. নামধেয় দলিলটি illegal, void, collusive, mere paper transaction, not acted upon, পণশূন্য দলিল হইতেছে, সে কারণে নালিশি সম্পত্তি. So once this written objection come into the picture, he cannot say, the learned trial judge cannot say that he is a domitus litis.
No.
My anticipation comes to true.
Yes, yes, Mr. Ghosh.
No, my lord, just before I just state the facts of the case. When initially, my lord, Sudhanshu Shekhar Midda Chaudhary was the owner of the property. His name was recorded, and he transferred the sold property in favor of his daughter Sondharai by demarcation. Subsequently, my lord, the property was sold to me in 2012. 2012, since the different number one and his associates were interfering with the possession of the sold property, my lord, we filed a suit on the ground that for position, so that they should not declaration that they should not interfere with our position. Well, in such a suit, the suit they filed a counterclaim, written statement with a counterclaim, and on that, the suit was proceeding went into the primary board. In 2016, my lord, you'll also see why I say, well, this is absolutely a fabricated and manufactured deed, because defendant number one, who is the applicant? Applicant is the wife of the defendant number one. You'll also find that is Gita Rani Nando, and he's tracing title from whom? His father-in-law, Atin Nando. Therefore, absolutely, my lord, we have taken a plea that this is a nothing but this is a forged and fabricated.
They should be added.
No, now, my lord, I tell you, Dr. Lordship, because we deny that there is this type of deeds are procured and has been manufactured.
Right,
Therefore, we have said, my lord, the dominance status, the plaintiff has to prove his own case. The plaintiff will say against whom he is sued the property. Now, my lord, in this particular case, my lord, we have said that since if a decree is passed, it will not bind the applicant, because the plaintiff will have a whether he'll get a decree or decree, well, he has the right to file a suit for declaration saying that this suit is not binding.
Publicity.
Now, my lord, to these, my lord, I shall be relying on a Supreme Court judgment that I will place before Lordship, my lord. In these type of cases, my lord, the plaintiff has a dominant status, that this type of addition should not be allowed. Your Lordship kindly considers this judgment and thank you. Well, this is unreported judgment, my lord. I shall be relying, my lord. Your Lordship, same thing. Thank you. If your Lordship will straightway come to, but this type of plea has been taken by the applicant, my lord, in this case also. And the court has, what the court has said, your Lordship will kindly come to paragraph 5. We have heard the counsel for the respective parties at length. At the outset, it is required to be noted that the defense in the suit filed application order 1 rule 10 and prayed to implement the subsequent purchasers as party defendants. The suit is for declaration, permanent injunction, recovery. As per the settled position of the plaintiff degree and or proper adjudication as per Order 1, Rule 10 CPC, nobody can be permitted to be impleaded as defendants against the wish of the plaintiff. Not impeding any other person as defendants against the wish of the plaintiff shall be at the risk of the plaintiff. Therefore, subsequent purchaser could not have been implemented. Well, although he's subsequent purchaser, but he's tracing for the title on the basis of a deed. Therefore, subsequent purchaser could not have been implemented as the party defendants in the application submitted to the original defendant. That too against the wish of the plaintiffs. Now, so far the reliance placed upon the decision in this court in the case of Rahul S. Shah Supra.
Yes. This is nothing but 2210A.
No, subsequently, you will kindly see paragraph 7 also. No, this is a case. You also the third
That
party.
is the leave. The court.
Please, my lord, let me finish. Let me finish, my lord. What I was humbly submitting, my lord, the deed on the basis of which they asking for pleading in my suit, my lord, your lordship said we are specifically denied. There was no, and your lordship can you see 2016 the deed was transferred, and when the made this application at the time of preliminary stage when the suit was at the verge of completion at the time of the hearing. Therefore, my lord, your lordship. Yes, at
It's
the
PW4.
Yes,
The defendant's evidence has not yet been started.
my lord, this is at the preliminary stage, and your lordship knows these type of applications are made to your lordship knows under section 58 of the Limitation Act. These are to avoid the institution of suit, because this suit is also barred by limitation. 3 years have already passed after the accrual of first cause of action. Therefore, well, the property has been transferred to him. This is this cause of action. Therefore, on the basis of that, my lord, he cannot be impleaded after the 3 years. This is also barred under the law, my lord. Your lordship kindly considers this also.
But my cause of action will start when the threat to my title. Yes.
Yeah, that is 2016. 2016. These type of suit, your lordship can you consider, but this is a case where the plaintiff.
I'm not touching to that. If his written objection is to that effect, that I am not touching your title, whatever title you remain.
On the contrary, we have said, this type deed has been collusively made by the defendant number 1 at the instance of. Your lordship can you see, this type of your lordship knows. Again, Dean over trial, your lordship can be considers.
Yes, definitely.
This is a case, your lordship knows in these type of cases.
But I cannot be non-suited.
Non-suited, he has a right to file a suit.
But my threat to my title, yes.
They can file an application in section 10 for consolidation of suits. Why in my suit? Because let him file a suit and file both the suit may be consolidated and my lord, one thing your lordship my kindly consider my submission, my lord, also, my lord, in this particular judgment, kindly consider paragraph 7 also. Paragraph 7, my lord. No, I cannot say them. Your lordship is wrong. No. এটা একই জানি তো ওই জায়গায় ওটা ইস্যু হিসাবে বিচার হবে ওটা ওরা সত্য আছে কিনা মানে demarcated plot according to my case demarcated plot
by 402. (2016).
and kindly record my lord we have objection because yes what is there in the record my
That
lord
is-
yes
That I have said to Mr. Ghosh.
yes yes
That is the blunder.
এখানে যে তোরা এটা এই জায়গাটা যে তোরা এই জায়গাটা বলি গন্ডগোল হয়ে গেছে
দাগও দিয়ে রেখেছে। Yes, yes. এটা কাগজ।
এইটা না বললেই হতো না এই যে জায়গাটা আমরা এটা বলি যখনই আমি বলছি যে এটা মানে কলিউসিভ তখনই তো
হ্যাঁ বলো বলো। হ্যাঁ আচ্ছা আচ্ছা।
হুম?
89. Zafar. ZA. Yes. Zafar. Job. Job. Number.
And was never actually. From such,
Okay. Yes, for the table.
from such transaction. Transaction. When a-
Judy, right?
Transaction and avoid document.
It's true.
The people have not reacted. So, first you have that was a. That's the great, like, should have had claim.
57 days.
Out of the entire plot.
Page 36. Did.
No. Plain, plain.
Plain. Oh, Milord.
it starts from page 13
Prayer Milord is at page
18
18.
Paragraph. Fine. Of the same. Six. As categorically mentioned. That. 100%. Right. Yes, happy place.
not 6,000 persons staying my lord they are the population of the particular village
Yes, sir. Me.
যখনই আমরা ডিনারও করলাম না তখনই যখনই তুই বলছি ডিনাই করছিস প্রপার্টি তখনই পাবে ব্যাংক এসে যাচ্ছে। ওখানে শুধু বলা উচিত ছিল যে সমাজে স্টেটমেন্ট এটাকে ইভেসিভ ডিনার করে দিতে, আমার কিছু জানা নেই। তাকে রাখতে হবে।
Still indicates that the might avoid freedom. Is this all the more necessary at night? Facts that at night. The court's gonna have to. Yes.
Five and seven.
What is their name?
They are also claiming that the
Claiming that
explicit
the-
right, same.
That. Fine. As a basic thing. Right, right. Plot number.
This can be constituted property.
In of Muja Jafford
Is Jafar Chowk.
station in.
Khejur.
Yes, this was
My lord, in respect of constituted property.
Alternative prayer is restricted to schedule Kh. Yes.
Number 1. The defendant are the proper place. But the right action interest of contributor.
Right.
Right action. Also,
The constitutional property, you should also find for the written statement filed on behalf. And it should be page 21. Constitutional property, the written statement filed on behalf of the defendant number 1 is that the acquisition of title from my vendors was not lawful. The paragraph 2. Sondarani was the
And according to the judgment, I am not cannot be said to be a subsequent purchaser. I am not claiming from defendant number 1. I am not claiming from defendant number 1. That's why.
counterclaim.
But they are exclusive right title interest, alternatively undivided portion. Same.
The defendant number of husband.
But
The
this
defendant
is-
number 1 possibly, subject to correction.
check it. 1, na?
Badi,
No, no.
Bibadi Gone.
এক নম্বর 5 ও 10 defendant number 1, 5, 10 and 20.
Number 1.
402, jail number 89, Mouja Jafar Chak, Toji number 2935, PS Khejuri, District Purbo Midnapur. একটু দিন।
Judgment. No judgment, right?
and or declaration of the a resulting marriage of the
অনন্ত নন্দ
yeah, the groups of by the group of I the Bible. That claim, claim and the counter claim. Plot number
plot number 102 by 402.
Right. This objection is true. And answer. For a competitive
And my lord, the entire exercise back to her.
The running for and add is going to the
Petitioner. My lord.
On the basis of
So they will have to serve, your lordship direct them will have to serve the copy of the plaint and
Everything is there.
ওখানে clear দরকার নেই।
Only trying to delay the proceeding.
তা ঠিকই আছে।
service of the based upon the identification. By the identification. It shall be allowed. That is dependent. The issues shall be as additional issues of correct. Such amendment shall be taken up. Such amendment claim shall be filed by the claim.
Copy of.
Filed by the claim. Additional issues shall be taken by the lawyer. The written statement filed by the file. W shall be brought.
If necessary, if good chooses.
যদি প্রয়োজন হয় রিকল করে নিয়ে আবার এভিডেন্স চলতে হবে বুঝলো
Thereafter,
the 2014 suit
division.
Mani, your lordship has not expressed any opinion.
The defendant number one. Apart from the defendant number 1, 5, 10, and 20.
Yes.
And the only file, right? Plain.
Again,
Extremely.
the application copy the name in it. Oh,
copy then. Without serving any.
I'm grateful. Yeah, the copy deal.
Plaintiff is the petitioner before your lordship. Suit for declaration and permanent injunction. In the suit, I filed an application for amendment of plaint. That application was rejected. I came before this honorable court. This honorable court pleased to allow the said application with the condition that I have to pay cost within 15 days. I could not. I go to pay the deposit on 16th day. Right, the client will be die. But kindly see that the amount of cost.
Can you consider the
Only 1 day delay. 1 day. No, there is puja vacation was going on. Can you see the order after puja? 15 days after puja vacation. Amendment allowed with the cost of rupees 25,000 to be deposited within 15 days by this court. By this court.
My lord,
Only 1 day.
kindly consider, my lord, the coordinate. My lord, kindly consider coordinate being passed the order yesterday. My lord, kindly consider. My lord, what is the illegality of the order, my lord, passed by the court below, my lord? My lord,
That court says.
my lord, court below has no power, my lord. There is no illegality. That is my lord. That is my submission, my lord.
30th November. Running page, second page was 1, 2, 3, 4, fourth paragraph. Court says I don't have the jurisdiction.
That the Honorable High Court had directed that the amendment made a copy of the claim. He accepted upon the petition. Cost of the claim. Cost of the opposite party. They to be cost of rupees 25,000. Opposite party. After the after the as the amount of 5,000 was not paid to the opposite party. Current court held at the time not be accepted and this damage claim not be accepted. I already said Notice of the view that as the High Court had made a time of exercise whereby the petitioner was asked to pay the cost of contribution. Learned court did not have the as it would amount to. Thus, there is no error in what for the prejudice. That's the
So tell, I right now don't have. Tell keep it. Yes, yes. Next week, can you fix it next week? In the meantime, I'll pay.
5,000, 25,000 as so I honorable High Court by generally the check of 25,000 the Bombay Court had not
Hey, my wife, I'll pay him by cash.
cash.
Yes,
Cash.
মক্কেল আসবে ক্যাশ দিয়ে দেবে
Not by RTGS.
Uh-huh.
The account of the opposite party, Mr. Bombay Lally advocate for party chairman. On its use. Okay, no. In the amount of the opposite party. What? That payment shall be made. Hours.
Well, it's the come from Purulia.
They can file the court below, my lord.
No, আমি এখানে দিয়ে দেবো। Well, can you take it up in next Wednesday?
To the plaintiff, to the defendant, my lord. Let them pay to the defendant. I will intimate this order, my lord. of the
Can you
Honorable High
give them
Court.
a matter returnable on Wednesday? In the meantime, he will pay.
Opposite party
Defendant.
directly or through the bank account of the opposite party. Party stand. Bank account and number. Shall be. That transaction, electronic transaction. The transaction.
Receipt. Yes, yes.
From the next.
All the next first. And then, march up. এই টাকাটা তুলে নিলে মক থেকে তাহলে তোমার ফিতে পারতো মার্চ আপ
My lord, 7 I beg to appear for the petitioner. Lord, I have to come back with service because my lord, earlier learned advocate who is appearing, I spoke with him. He said that he gave it to NOC at the time of mentioning. It's a transfer application, my lord. I am the wife petitioner, my lord. Section 24, my lord. Stay was granted on 16th May for 10 weeks, which is going to be ended on this month, my lord. That is why I mentioned for extension of interim order. Because my lord. 26th, yes, my lord. Earlier occasion, Mr. Shah is appearing. My lord. Great.
H. my lord, I beg to appear for the OP party number 1.
I beg to appear for the
Aniruddha Chatterjee is
opposite
leading
party
me in
number
this matter.
6, my lord.
But can it be on 24th?
My lord,
24th.
Before that, my lord, some urgency. I'm appearing for the defendant number 6, my lord. I tell you, lordship. Yes, my lord. Nothing, my lord. Keep his
Your lordship, the interim order
short
that is
date.
there, your lordship, is till August. Till August 7, your lordship. That may be.
Well, this was supposed to be fixed. Well, for hearing it was fixed.
And the amendment of plaint was rejected by the learned trial judge only on the pretext that it is at a belated stage which has been filed, your lordship.
I tell you, lordship. It's a
First
suit
of
for
first.
partition, my lord.
Grateful.
Grateful, your lordship.
Very well, my lord. Very well.
Enough.
Yeah.
Yes.
Deeply.
My lord, item 9 and 10, my lord, I beg to appear on behalf of the petitioner in both the matters. Mr. Aniruddha Chatterjee is leading me, my lord. Anytime after 17, my lord, there is urgency, my lord. In both the applications, there is urgency. I would have pressed it, my lord.
August, my lord. Let it be 1st August. 1st August.
My lord, again it will be delayed, my lord. Because the next date, my lord, today was the next date in the court below. No interim orders are required. Just that, my lord, let it come in the daily list, my lord. Very well, my lord. I'm so grateful.
My lord, I am appearing on behalf of the defendant petitioner, my lord. In pursuant to your lordship's last direction, my lord, I have served the copy of the application, my lord.
Well, I'm appearing on behalf of the
My lord, there is an application for substitution, my lord. Can number 1. Yes, my lord. My lord, one of the legal has already record, my lord. And another thing. Yes, my lord. Yes. In pursuant to your last direction passed by your lordship, my lord, I have served. Two. My lord, petitioner number 2. Namely, Sobhita Rai, expired on 27/11/2020. My lord, page number 5, paragraph number 2. My lord, already I have given the schedule, my lord. If you, my lord, page number 7. Yes, sir. Yes, my lord, I am ready. Yes, my lord.
My lord, I have been led by Mr. Shubir Mukherjee. Kindly fix it on.
July.
24th July. Gratefully, Your Lordship. Gratefully, Your Lordship. Grateful.
I appear for the petitioner.
Your Lordship, in this matter, Mr. On Manager is appearing for the respondent number 4. I'm playing for a very short pass over, Your Lordship. Very short pass. So there are others, my lord.
There are others, the bank is also
I
there.
am the purchaser. I have purchased the property.
We have served, pursuant to your lordship's earlier direction, we have served, my lord. Indian Bank, my lord, and my lord, Reliance Asset Reconstruction Company. My lord, may I just state the facts in brief, my lord?
My lord. It seems so, my lord. But I would only say, my lord, it's only a technical thing, my lord.
My lord,
Application was filed. Application was filed by them, my lord, but not for modification. It was not for incorporating the fact that they had not given consent. On that application, order was passed.
My lord, may I just place the facts, my lord? My lord, an application was filed by might be before the DRT. Well, I am neither the borrower nor the guarantor, my lord. But before the DRT, we filed an application, my lord. Now, the petitioner, my lord, is because my lord, we are the co-owner of the property. I am neither the borrower nor the guarantor, my lord, but I am a co-owner of the property. One Diptilata Mukherjee, my lord, was the owner of the property. Now, my lord, during the lifetime of Diptilata Mukherjee, my lord, the respondent number 5, DRT rejected it. We went before the DRT. Now, before the DRT, after the appeal proceeded for a considerable time, the bank came up with a document that the loan has been assigned to some Reliance Asset Reconstruction Company. Now, my lord, I can show, my lord, from the documents itself, my lord, that before the DRT, when the matter was pending before the DRT, my lord, then the loan was assigned, my lord. That was not pointed out before the DRT. In fact, my lord, the sales certificate which was registered in favor of, my lord, the purchaser, my lord, that was also done after the assignment by the assigner, my lord. So, my lord, we said, my lord, that when this fact came to the knowledge, to our knowledge, we said that we will file an objection. Now, my lord, in the DRT, my lord, because DRT proceeding was already over by that time. So, my lord, on 24th, my lord, 24th of September, my lord, they filed an they filed an application for substitution. On that day, it was allowed, my lord. Now, my lord, the order, my lord, which the learned DRT passed, my lord, was that, my lord, the Reliance Asset Reconstruction Company be added as respondent number 1A. Now, my lord, we did that, my lord. Respondent number 1A, Reliance Asset Reconstruction was added. Now, my lord, after, my lord, the appeal proceeded, my lord, without any application from behalf of anybody, my lord, the DRT passed an order, my lord, that no, addition won't do, you have to substitute. You have to delete the name of Indian Bank, and in that place, Reliance Asset Reconstruction Company would be there. Now, my lord, in my contention is that, my lord, the presence of Indian Bank is necessary in this matter. Because, my lord, what admittedly happened is that, my lord, the loan which was extended by the Indian Bank, my lord. Yes, we have served the bank, my lord. We have served the bank, my lord. Because, my lord, Indian Bank, my lord, was
let them be. I am not opposing as such his prayer, my lord, because I am the should be. They should remain.
They should remain.
No difficult. Only kindly expedite the proceeding. I am the purchaser. I am at a limbo because of this proceeding.
My lord.
The revision of application has been added in terms of the receipt.
My lord, the receipt, my lord, it was not at the time, my lord, it was.
In view of content number 1 and 2.
My 25th April, my lord. 120, my lord. Page 120.
By the same order on the following order. A, that assigned place has transferred the donor account. And it responded number 1. But for proper admin of the I want why is it that
Because, my lord, the mortgage, my lord, was extended, my lord, admittedly after the death of my lord, the guarantor, my lord. Now, my lord, the bank says, my lord, that they have the will, my lord. But the mortgage cannot be extended on the basis of a will, my lord. Until analysis is provided, my lord. Dipti Lata Chatterjee, my lord, she, my aunt, my lord. My borrower is my brother, my lord. And my lord, Dipti Lata Chatterjee was our aunt, my lord. Now, my lord, she died without any issue, my lord. We are the legal heirs.
the mortgage after the death of the guarantor? Even back of the petitioner.
My lord.
Although the SIC, although the assignment applied.
During the process before the DRT, my lord.
Such
DRT and DRT.
DRT.
the loan to rely in favor of rely asset
22nd March assignment date.
had not been brought on record by the bank for modified reason. Next, action of the bank prior to assignment
March 17 assignment.
had a
Page 120, my lord. 120, my lord. 120, my lord.
Applications of the interest.
My lord, we filed an application, my lord, thereafter, my lord, because, my lord, our consent which was recorded, my lord, because it
challenging. What did you challenge?
my lord, we challenge, my lord, the recording of this the order, my lord, that my lord, sale notice, my lord.
The sale notice was rejected. Thereafter, the petitioner filed the appeal for the title. I think it was registered as a of the assignment
My lord.
and then wait for
My lord, we have not prayed for as a substitution, my lord. My lord, may I just take you through? My lord, page 90, my lord, is the order, my lord. Kindly see the 90, my lord, page 90. This is where, my lord, for the first time we came to know that, my lord, the loan account has been assigned, my lord. Now, my lord, that was informed by the bank. Substitution has been given liberty to the respondent bank. One A. My lord, thereafter, my lord, against the order dated 25th April, my lord, where my lord, our consent was recorded, my lord, the substitution application filed by them was allowed, my lord. We filed an application that we have never given consent. We intended to file an objection, my lord. No, my lord, kindly seize the order, my lord, of the tribunal of 20. Now, my lord, the applicant may be impleaded reliance as a constitution as respondent of 1A. My lord, not asked, my lord. That was
Let
filed
him
by the
produce
bank.
the application to us.
That was filed by the bank, my lord.
Let him produce the application, my lord. If it is for addition or not, order 22 rule 10 possibly. Application টা আছে তোমার?
The asset has been transferred by the Indian Bank to Reliance Capital Legend Construction Company. Accordingly,
As a respondent bank, my lord.
allow filed a substitution application. Next one. Where is your, you didn't file any application?
We didn't file any application. Bank filed a substitution application.
And added. Order number 1. So what is that order of 25th April?
My lord, 120, my lord. My lord, last paragraph, let the
Was allowed by an order dated April 25th. As the name of the record of one review, despite such substitution. So, that is the proper remedy of the. But that was like.
My lord, we have made, my lord, we have, my lord, kindly, my lord, appreciate page 83, my lord, of my application, my lord. We have filed an application, my lord. That substitution application was filed on the date, my lord, when the order was passed. We were not given opportunity.
Have you said that it should be retained?
My lord, in the application at page 82, my lord. Application at page 82, my lord. This is my application, my lord. Now, my lord, this application was disposed of by my lord, order dated order. My lord, page 82, it starts, my lord. My lord, it ends at page 88. 88 is my prayer, my lord. This application was considered by the learned tribunal said, my lord, that there was no reason to modify because my lord, substitute additional party has already been done. Because my lord, by order of 25th April, my lord, the respondent. 2018, my lord. My lord. My lord.
That is
My lord.
No, 8th June it was rejected, 8th June 2018. The lordship will
These
find in the
applications- these
impugned order.
applications are Rejected, my lord, on the
Impugned
fact-
order, page 2, first paragraph.
And my order is at page 83, my lord, also.
thereafter by an application.
Dated 25th May 2018, yes, affirmed.
Clarity explain why that was required to
Right.
contribute as a respondent. And wait for modification of the order dated April 25th, 2018. The extent that numbers 1 and 2 continue as respondents in the appeal. That is your case.
My lord, we prayed, my lord, that my lord, the kindly see prayer A, my lord, at page 88. The submission of your petitioner's advocate that the learned counsel for the appellant states that the applicant moved by the respondent bank be allowed and in place and instead of Reliance Asset Reconstruction Company Limited be substituted. The notice be issued. Continue. We want them to continue.
For paragraph 13, he has given the reason. Paragraph 13, lordship says, my lord, he has said,
And paragraph 13 of the said application deals with the reasons assigned by the petitioner as to why and its authority for respondent numbers 1 and 2 is retained as respondents in the appeal. The honest court, the honest appellate tribunal
ওদের থাকাটাই ভালো ওরা পালাবে
পালিয়ে যাবে না।
কিছু হলে তখন আমারও তো problem আছে।
and considers the fact that the appeal arises out of an order passed by the DRT
33.
33.
had not been 33 in the presence of the bank and without recording of transfer of message number 1 and as petitioner has damaged the bank just right now. So, that the order is by point number 1 and comments and the past completion of
Can it hear the appellate tribunal to proceed expeditious?
merits of the claim of the petitioner against the bank or against the respondent numbers 1. They are all included here.
Well, they are all included.
Honest tribunal have dispose of
No problem. Appellate tribunal 4.
Yes, on behalf of the
What's it? Open 4. No problem.
I am for the petition.
I am opposing this.
So
My lord, my application filed under section 47 was dismissed. My lord, what happened is this. My lord, if your lordship, my lord, takes the list of dates first. Yes, my lord. My lord Justice, my lord Bibhas Chandra Dey was kind enough to heard this matter for days together, and under the directions of his lordship. Yes, my lord.
This really should take not take more than 15-20 minutes. Your lordship would recollect, my lord, this matter was appearing in my lord's list when I had indicated that due to pendants showing pendency of this, they are adjourning the execution before the trial. But I would humbly beseech that would once again take a.
Yes, my lord, under the direction. Yes, my lord.
But notes of argument, we have not made our full submissions.
My lord, I have got no choice.
But we can do it here.
No problem. My lord, if your lordships kindly take the list of dates first. And I will show just 3 dates. My lord, on the petition, synopsis then. Have your lordship got it? My lord, I am emphasizing on 1, 3, 6 and 5. 5 and 6. Well, 1, the learned sole arbitrator made and published award wherein Radhakrishna Poddar was award holder. In fact, there was no arbitration agreement. Number 3, my lord. Number 2, your lordship can skip it. Number 3, Radhakrishna Poddar had died. Number 4, Radhakrishna Poddar died. Radhakrishna Poddar was substituted by his heir, Srimati Gayatri Devi Poddar. The substitution order by the learned court without having jurisdiction. My lord, what happened is this, my lord, they have filed title execution case, not arbitration execution case, before the 4th, my lord, civil judge senior division. My lord, the proceeding was on till 2018 on a defective court. My lord, then they have filed an application for withdrawing that application. The learned court was pleased to direct them, my lord, the decree holder, to file the same to the court of competent jurisdiction. They did not file the same. They filed arbitration execution. So, my lord, my first point is this. It is a new filing on 2018. My lord, I think I can make your lordship understood, my lord. My lord, so, my lord, my first point is this. My lord, decree was inhaliated decree. My lord, decree was of 2001. They have filed afresh on 2018. Your lordship knows Article 136 clearly attracts. This is my first point. My lord, now the question may be raised whether at the time of execution I can raise objection, because I have missed to file an application under Section 34 of Arbitration and Conciliation Act 1996. My lord, my submission is this: at the time of enforcement of decree, my lord, the objection can be raised. My lord, I have already disclosed a judgment that is in the notes of argument. Your lordship may have. My lord, if your lordship says, my lord, I can show it to your lordship. My lord. My lord, Section 47 ground is this, my lord, the decree is clearly, my lord, barred by limitation. It cannot be executed. But my lord, other points which I should raise under Section 34, that I have missed. because of, my lord, wrong advice. That is, I should not say about anything about against any advocate. It is only limitation. My lord, may I show? My lord, your lordship will have it at after page 61. 61 is the certified copy, it shows.
61 of the revision.
Revision application, fine, last. Last. Your lordship got it, my lord. My lord, may I place, my lord? Today is fixed for passing the order. Both sides filed Sajira in their respective advocates. From the case record, it appears that order number 37 dated 16th December 2022, my lord, it should be. JDR are directed to make payment of the award amount by 3rd January 2023 in default. Order of civil imprisonment shall be passed. Void order number 38 dated 3rd January 2023, it appears that no payment made by the JDR and there is no adjournment prayer is making for. On the day, that is 3rd January 2023, written notes on argument filed on behalf of the JDR and the matter was heard at length. Today is fixed for passing the order in respect of the same. The original arbitration execution case was filed in the year 2002 before the learned 4th Civil Judge Junior Division Alipur in connection with the arbitration award dated 22nd December 2001, passed by the learned arbitrator Sri Sujit Kumar Laik, Advocate, High Court, Calcutta. Subsequently, the arbitration execution proceeding was withdrawn from the learned court of 4th Civil Judge Junior Division Alipur on 29th September 2008. My lord, date is, my lord, very important. For want of jurisdiction, and the same has been refiled. It is not refiled, fresh filing, my lord. Refiled immediately before the learned District Judge 24 Pargana South on 4th October 2018. And the learned District Judge was pleased to transfer the case record to this court for disposal. The contention for the learned lawyer for the JDR is that the case was filed in the wrong forum and the matter has been dragged for 16 years. My lord, kindly mark it, my lord. And that the case ought to have been transferred to appropriate forum of the district judge, rather withdrawing. My lord, they have withdrawn, not asked for transfer. The same as such, the execution proceeding is badly barred by limitation. In this context, the contention of the learned lawyer of DHR is that more than 10,000 cases has been filed. My lord, no record is there. It is the just submission, my lord, from the bar before the court of the civil judge at Alipur. Subsequently, on the basis of the decision of Honorable High Court at Calcutta, the...
I'm sorry, my lord. Uh, 2017 possibly. Khoda apik, my lord Justice Banerjee said, Sanjeev Banerjee, yes. 2017 most probably.
Well, then, on this context, the contention of the learned lawyer for decree holder is that more than 10,000 cases has been filed before the Court of Civil Judge at Alipur. Subsequently, on the basis of the decision of Honorable High Court at Calcutta, the same was withdrawn and filed before the learned district judge. My lord, they have not asked for transfer, my lord. That is the crux of the matter. My lord, they should ask for transfer and they should file it as, my lord, title execution, and they should ask for amendment so that the arbitration execution can become in picture. They didn't do this. They just withdraw and filed afresh from title execution to, my lord, arbitration execution. Delay has not been explained. Nothing, my lord. No sentence is there, subject to, of course, correction. And my lord, about this submission, this paragraph submission, my lord, there is nothing. This is just a submission. The learned lawyer for the judgment debtor filed written notes on argument on 3rd January 2023, whereas the decree holder written notes on argument on 16th December 2002. The contention of the learned lawyer for judgment debtor is that the fact there is no arbitration agreement between the parties, but somehow the decree holder has managed to obtain the arbitration award under section 35 and 36. My lord, I should be, my lord, frank to your lordship, my lord, I should raise this application, my lord, under section 34. Definitely, my lord, because there is no arbitration agreement. But, my lord, for wrong advice, my lord, that has been happened. However, my lord, there is a serious question of, my lord, limitation. Whether the decree is alive or not, that is the question to be, my lord, adjudicated. And, my lord, the 10,000 cases and the judgment of Honorable High Court or any judgment that has not been, my lord, argued, or that has not been, my lord, that is the mere statement from the bar. My lord, may I then?
My lord, I'm sorry, my lord, it's 20th of May, 2011. 20th of May, 2011. That judgment.
But section 35 gives finality of the arbitral award and makes an award binding on the parties and all the persons claiming under them. So, as section 36 concerned, it deals with the execution of the award. Here, in this case, the judgment debtor has not availed of the provision of section 34 to challenge the award. My lord, decree is, my lord, totally barred by limitation. That is the point. The execution is, my lord. Real. I try to see. দেখো তো পেজটা। My lord, if your lordship kindly takes page 28. 28, my lord. That this petition is made by and on behalf of the judgment debtors, award debtor above named, that your petitioner states that the decree holder, award holder have initiated the instant proceeding for execution of the decree dated 22nd December 2001, culminating from arbitral award made and published by A.K. Laik, advocate, sole arbitrator. Your petitioner that your petitioner state that the learned arbitrator was appointed by the decree holder, award holder in compliance with the conditions. This is my only case. My only case is, my lord, this is their fresh filing. Since they have withdrawn and the arbitration, my lord, and the title execution turned to an arbitration execution. So they have not asked for amendment and they have withdrawn, not transferred. My lord. My lord, if your lordships my lord, if your lordship take my notes on argument. My lord, my notes on argument is spiral. No, it's spiral. ফিরে যেতে পারি বল। না আছে তো যা My lord, kindly take my notes on argument. It's spiral binding. And my lord, I also rely upon section 3 of Limitation Act. I will come to that, my lord. My lord, your lordship kindly take page 83 of the compendium, my lord. '83. Running page 83, my lord, judgment page 74. My lord, paragraph 82, your lordship got it, my lord. Issue of non-arbitrability can be raised at 3 stages. First, before the court on application for reference under section 11 or for stay of pending judicial proceeding, that is section 8, and reference under section 8 of the arbitration. Secondly, before the arbitral tribunal during the course of arbitration proceeding. Thirdly, my lord, thirdly is important. Before the court at the stage of the challenge to the award or its enforcement. This is, my lord, my only point on this issue. My lord, that section 3 of Limitation Act. And this is, my lord, reported on 2000. Oh, I'm sorry. Page 80, paragraph 86 is also saying so, my lord. The first phase was from the enforcement of the Arbitration Act. Then. No, my lord. My lord, if your lordship kindly, my lord, they have filed the, my lord, I have already submitted that they have filed the execution application on 2028 for execution of a decree passed on 2001. 2001, my lord, then, my lord, they can raise the, my lord, objection that since they have filed, though it was a defective filing, but they have filed it. Their intention was to execute. My lord, if your lordship kindly comes to page 172, running page 172, there is another judgment, Delhi Development Authority versus Durga Construction. My lord, this is collected from internet, my lord. Paragraph 17, my lord. Your lordship got it, my lord. The case of delay in refiling and are different from the cases delay in filing, inasmuch as in such cases the party has already evinced its intention to take recourse of the remedies available in courts and has also taken steps in this regard. It cannot be thus assumed that the party has given up his right to avail of the remedies. However, this is the important one. However, in certain cases where the petitions or applications filed a party are so hopelessly inadequate and insufficient or contain defects which are fundamental to the institution of the proceedings, then in such cases, the filing done by the party would be considered honest and of no consequence. In such cases, the party cannot be given the benefit of initial filing. A similar view, my lord, thereafter, my lord, not necessary. My lord, I want to save your lordship's time. My lord, then, my lord, I want to Limitation Act, section 3, my lord. My lord, may I hand over my section 3? Thank you. Thank you. Section 3, subsection 1, my lord. Subsection 1, subject to the provisions contained in section 4 to 24, inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. Well, this is my submission on section 3. Thank you. Last. My lord, then, my lord, I am relying upon, my lord, Arbitration Act. My lord, they have filed wrong forum, but about the definition of principal court, that has not been amended as yet. Since 1996 to
this was filed before the civil judge senior division.
it should be filed before the learned
By
district
district
judge as arbitration execution or money execution.
Same Alipur court, but before the civil judge senior division it was filed. It should have been filed before the district judge. That's the only thing.
Well, the point is this: they have not asked for transfer; they have simply withdrawn it and file afresh, not the same as directed by the learned court. My lord, your lordship kindly have a look to their own. My lord, I am relying upon their notes on argument. Yes. That is the basic defect. According to the judgment of my lord, Delhi Development Authority versus Durga Construction. My lord, if your lordship kindly, this is my last argument, my lord. If your lordship kindly take their my lord, notes on argument, it is unbounded volume. Yes, my lord. My lord, page 2, my lord, I want to rely upon. Eta na thakle tin. Unbounded. My lord, may I hand over my own copy? My lord, page 2. Only one page I will show, my lord. Page 2, para 2, my lord. Radhakrishna Poddar, since deceased, the original award holder passed away on 24th August 2014. My lord, he has been substituted by an order passed by a court which has got no jurisdiction. And subsequently, by virtue of this substitution, they are carrying on the proceeding. Then, my lord, and the opposite parties, being the legal heirs of Radhakrishna Poddar since deceased, were substituted by an order dated 30th October 2014, and accordingly the tabular statement was also amended. A copy of the application for substitution filed. No, subsequent. Radhakrishna, other years were also there. A copy of the application for substitution filed by the opposite party in, my lord, kindly mark it, title execution number 9 of 2002. This is not arbitration execution. This is not money execution. So they have filed afresh in 2018. Is annexed here to such and such in or around the September 2018, the opposite party's award holder became aware that the learned civil judge senior division Alipur has no jurisdiction, and the opposite party withdrew the proceeding and filed execution, being arbitration execution 535. So new filing, my lord. Arbitration execution 535 for execution of arbitral award on order is here, my lord. They have annexed it. They have annexed it, my lord. I am showing, my lord. I am showing. It is here. It is here, my lord. If your lordship kindly take page 14, perhaps. Page 21, not a substitution. My lord, before that, page 14. Page 14 is the substitution order by 4th Civil Judge Senior Division, who lacks the jurisdiction. My lord, who have carried on the proceeding. That's right, my lord. But, correct, my lord. But, my lord, this, who has carried on the proceeding? Order at, my lord, page 21, 22. 21 it starts. 22. 22, my lord, kindly come the ordered portion. That the petition dated 7th September 2018 is allowed. Let the same before the appropriate forum. My lord, that is all, my lord. I am deeply obliged.
My lord, firstly, my lord, in my humble submission, my learned senior friend will correct me if I'm wrong. This point of the legal heirs being substituted, this does not form part of the section 47 application, does not form part of the revisional application. So this is not a ground urged ever and argued, my lord, for the first time from the bar, not even pleaded in the revision. Secondly, my lord, if I have been able to understand the submissions of the petitioner correctly, they are harping only on the point of limitation. Because they say that the award was 2001, and now since you have filed in 2018, that is barred by limitation. That's the sum and substance of their argument. 12 years? 12 years, yes. Now, my learned senior friend had placed the application, placed the order once at page 21 of our compilation. Kindly comes to the page 16, which is my application for withdrawal and filing before the appropriate forum. That is the exact ground which we have stated. That principal civil court is the district judge. We have to file before that. So give us liberty to withdraw, to file it before the appropriate forum. That application was allowed and that order was passed. Now, to answer my learned senior friend's submission that this was not a title execution and instead we filed a different execution, arbitration execution, kindly takes a look at the order sheet in the arbitration agreement, kindly sees the first order. Kindly sees the first order. We filed the title execution. The court says no, since it's an arbitral award, it should have been renumbered as arbitration execution case. Yes. So I filed title execution. So this, since it was execution of an award, so that was. That defect is not there. And the substitution point, my lord, argued is not taken in 47 or, my lord, in the revision also. My lord, thirdly, though my learned senior friend had not really pressed the point, but I would also rely on, my lord, section 34 and section 4 of the Arbitration and Conciliation Act, that the recourse available to an award debtor is, my lord, to challenge it, to file an application for setting aside. And in the event they do not do so, my lord, section 4 comes into play, which is waiver. So whichever provision a party can approach, they have consciously not done so, that amounts to waiver. Yes. But may I place it, my lord? Waiver of right to object. A party who knows well that, then any arbitration.
My lord, may I help?
Thank you.
Sentence खाली बोलो. My lord, after completion of arbitration, my lord, this section will not come into play. Execution will come as per civil procedure code.
But kindly see section 4. A party who knows that, then any provision of this part, kindly marks the word part, from which the parties may derogate, or any requirement under the Arbitration Act, arbitration agreement, has not been complied with, and yet proceeds with the arbitration without stating his objection to such compliance without undue delay, or if a time limit is provided for stating such objection within that period of time, shall be deemed to have waived his right to so object. Now the 4A is any provision of this part. Part A, or part 1 rather, is, my lord, the entire provisions till section, my lord, 43. So section 34 also comes within part 1. Part 2 is, my lord, enforcement of certain foreign awards. This part. Yes. Part 1 is still section 43, which includes the setting aside provision of section 34. So no
Petitioner herein he is a tenant. He is running commercial shop since 1991. Therefore, only one. Yes, I have appreciated, but only difficulty, problem is that at the wrong advice of the lawyer, he could not deposit. Only one thing that is mattered was vanished from the list. So it is not my fault. 4 months mattered.
When the scope is there to challenge this point, to take this point in the appeal.
Challenging, has been filed, challenging and order dated. June 2020. What was the criminal billion with an order by yes. Struck out. So, section 72 of 1997. The court found that court mechanically found I have not deposited. But when I am disputing the landlord and tenant, I am not liable to pay the deposit the rent. Because yes, already I have already deposited in the court. Court accepted. My lord, can you see the order sheet? That the learned court below did not accept the fact that the rents actually deposited also related. 4th February 2019, where is the judge, that is the court bill has put the signature, and time to time, for every month he has deposited rent, but without considering the same. And 7 of the act. Petitions have been filed beyond the period of prescribed by law. In the meantime, the suit proceeded has been decreed on
30th June
2023. Thus, the petition of application, in my view, has become infructuous. As the petitioner has other revenues that is the same points which have been raised.
Revision.
Okay.
Leave to file without certified copy, you can appeal without file on January 2022 before the tribunal under the senior citizen maintenance and welfare of senior citizen. No number has been given, nothing has been done, no date has been given. Not asking leave to direction without certified copy.
What is the challenge?
Challenge about the senior citizens have not been really. That's why they have prepared an appeal. That has not been neither been registered, they have been received by putting stamp. No date has been filled. I am speaking it. Yes. Right.
First matter.
ঠিক আছে পরে আছে জান হ্যাঁ হ্যাঁ ঠিক আছে আমি বলছি নাকি আমি চলে যাচ্ছি ঠিক না
একটা 15 I was before the judge. This was my last matter. একটা 10 হ্যাঁ
I'm sorry.
I was telling the senior that this is a regular picture with bylaws.
But may I just very bad situation. Learned since trial court is hearing a matter. My revision pending. Learned friend mentioned yesterday. And 150, 159. But I'll get the file.
This file is there.
This file is here.
Item 159.
But the problem is, no, only thing will not, otherwise I wouldn't have troubled your lordship. The reason is the learned judge is not hearing the matter even as I submit before your lordship. Refused to grant adjournment. There is a not to attend there. Despite that, morning one party, afternoon another party. This is happening. I want an
Fourth civil judge senior.
it's a very good thing, not for the bar, but otherwise good. But you know, the fact is, I'm not. This is
Order 39 rule 2A.
Order 39 rule 2A.
2A5.
First pillar of finding given that this is without jurisdiction, triable issue. May I?
159. 159.
159.
Caveat.
No caveat.
No caveat.
I am praying for a stay, my lord, limited for 2 days. It's listed 159. My lord, I'll come at 4:30, my lord. Tomorrow. Grateful, my lord.
I will see what I
This one. Commercial. I'm not saying the names, but kindly take it up.
আসবে
It was
বলে
fixed
দিয়েছেন বাবা
yesterday at,
লিখে নিয়েছেন লিস্টে আমার স্লিপ দেবে লিখে নিয়েছেন থ্যাংক
I
ইউ
believe if at all called up. I'll finish you. The fact, Sarkar. The question.
Still going on. Milord, I'll find out, Milord. By evening today, I'll find out. Milord, I'll find out and come and tell my lord's officer at 4:30. Injunction in connection with Order 39 Rule 2A. This is in the contempt petition and injunction. In the suit they haven't got. Now, under this, Milord, guys, they want an injunction. It's not possible.
Passed by an appellate court.
No, actually, I'm not. No, I'm not taking this. I'm not saying like that. But actually, we present that picture. That's
She started lordship, sorry, lordship, kindly give any delay. It was there fixed yesterday.
So, may I leave my yard?
I do not mind doing it on a Saturday, your lordship. I have no difficulty.
Certainly not. I don't like to take, I don't like to break the condition. Certainly not. Mr. Major can do that, my lord. I have not done that. Huh? Oh, no. On Saturday, nothing to be done. So High Court is concerned. Saturday and Sunday, not for the High Court and Supreme Court. Mr. Major can come, but I will not come.
Up again, I think. কাঁধে করে দেখতিস, কাঁধে করে আনিস কাঁধে আমার ওখানে আমার ওখানে জায়গা ফিক্সড আছে কেওড়া তলা নয়, ঠিক ওখানে জায়গা ফিক্সড আছে কেওড়া তলা নয়, কাঁধে করে আনিস।
Well, may Order 7, Rule 11. Order 7, Rule 11. Yes. But I have covered only 5 minutes, I think, I know. But another ground for setting Order 7, Rule 11 was the undervaluation. And on that, I cite a judgment of a division bench, and I don't have to argue much. 2009, Volume 4, Calcutta High Court Notes, 425. Paragraphs, important paragraphs are paragraph 11, 15, 12. 11, then 11, 11, 14, 14, and Milord, 18 and 19. What happened in this case, not the division is, can you take the judgment, Milord? No, put it. May that kindly come to paragraph 11 to get the fact. 11. There is no dispute that in a suit for declaration and permanent injunction, suit is valued according to the valuation of the relief. And where the nature of the declaration is such that it has no objective standard of assessing the valuation, the plaintiff can value relief accordingly. But in a case where from the case made out by the plaintiff, it is apparent the relief is capable of appropriate valuation according to the case made out by the plaintiff. In such a case, plaintiff cannot arbitrarily value the relief according to the whims. Let this come. We have already pointed out, paragraph 13, we have already pointed out the plaintiff has paid for declaration that agreement by which he got the money feasible by fraud. In such circumstances, in our opinion, relief of declaration as the agreement of advancement of more than rupees 17 lakhs was vitiated by fraud cannot be valued at rupees 50. Similarly, prior for the declaration and permanent injunction, the plaintiff is the owner of the vehicle, which is on its own showing valued more than rupees 10 lakhs, and for permanent injunction cannot be valued at rupees 50. In our case, the declaration agreement for sale are not binding, not valid. We thus find the relief of declaration examiner. Please now, Milord, kindly test regarding jurisdiction point that is not relevant, doesn't arise here. Paragraph 18 and 19, Milord. In this case, in course of hearing of the application for injunction, the moment the trial judge found, paragraph 18, that the plaintiff had taken more than rupees 17 lakhs by way of virtue agreement, ought to have asked the plaintiff to value the relief properly. That is, amount received by him, and for payment of adequate court fees on the amount. If in spite of such direction, valuation was not corrected, the duty of trial judge to reject the plaintiff. If the valuation was made and court fees were paid thereon, trial judge should thereafter return the plaintiff for presentation before the appropriate forum. Finding trial judge therefore becomes final court become 819. Let's see what direction court the gave. On that ground alone, we set aside the order, impugn, without entering the merit. We give leave to the plaintiff to correct the valuation and pay the adequate court fees. And if the valuation is corrected and adequate court fees are paid, the trial judge will return the plaintiff to the learned advocate plaintiff for presentation before the appropriate forum. If, in spite of such direction, plaintiff does not amend the valuation or pay the adequate court fees, court will reject the plaintiff in terms of Order 7, Rule 11 of the court. Our case, declaration agreement for sale is void, etc. Our case, they said agreement for sale is void, and agreement sale is part of record. And valuation is nearly on an average 1 crore.
What did the learned court below say about the valuation? How was this point dealt with?
Yes, valuation paragraph, I show you, see plain. Yes, yes, not plain. Oh, impure. Oh,
Yes.
sorry, well, no, that's been turned off. He has said he cannot be dismissed, must be given a chance. Yes, please come to Miller, running page 282. Well, the first continuing paragraph. Internal page 3, running page 282. The last 4 lines of the paragraph declaring he's the owner of Fedule, an agreement under challenge is null and void. Along with some agreement challenge, the agreement for sale. Consequence relief, thus plaintiff is entitled to put his own valuation. Moreover, it is so well settled, unless plaintiff is given opportunity under order 7 to 11b to correct violation, plaintiff cannot correct, reject. That's why there is no reasoning, nothing has been given really. That agreement for sale is cannot be valued, has to subjectively, is objectively valued, and the same agreement said value is this apartment sale which is saying null and void is without the 106 suits, the same apartment, different agreement apartments, valuation ranging nearly, let's say 1 crore per average it comes to. Therefore, we said yes, valuation, not the reject. If the question, the other point, if the plain otherwise survives, then Miller, he should have given opportunity, the direction for correction, pay the valuation, court fees, and then carry on. If you don't, plain and reject. This first point. Second point, I'm only this is Mr. Rajyothi's fault. He will not, his last evening found out a case reported in June, EIR. This one, only last month. That judgment, the Madras High Court, relying on Supreme Court, has held and in fact passed an order rejecting a plaint under Order 7 Rule 11 for non-joinder of necessary parties. In our case, the plaint clearly admits and say paragraph 1 that 50 owners, 50 companies, the 30 companies are owners of this property. And they are the vendor of the property, as shown in your agreement for sale. 50 companies are vendors. They want, and they have to say. 50 companies are not made parties. And on the face of it, they have, in spite of objection, matters went on for 5, 6 months, did not add them. Therefore, Supreme Court says, therefore, court is incompetent to pass a decree for cancellation, for any declaration the agreement is bad or good, unless all the parties to the agreement are made parties. Court becomes, therefore, there will be no cause of action for claiming that the agreement is good or bad or defective and should not be implemented, only if all the parties to the agreement were vitally affected thereby are made parties. On that, Madras High Court single bench judgment and following Supreme Court, I will not take long. EIR 2023 Madras 174.
Sir, 174.
2023 Madras. Copy চাই তো? একটা কপি আছে রে?
174.
পড়ে দিয়ে দিচ্ছি। পেয়েছো তো? আমার বইটা কোথায় গেল?
আপনার
Kindly come to paragraph 3. I shall find this. It was under Order 7, Rule 11, matter ki discussion. Paragraph, sorry, 80, paragraph 1 also. 1 also. This is case under Order 7, Rule 11. It came to the order refused to reject that. Then kindly come to paragraph 3. Paragraph below, kindly come to paragraph 18.
18, 19, 20.
18, 19, but reported from Supreme Court really. Learned counsel what the petitioner would submit. Respondent had not included the publisher as party. As well as suit for defamation, the publisher was not made a party. In a suit for defamation, publisher is a necessary party. Defamation. In all Supreme Court, the report is given below. That judgment I have brought with me, Lordship can see it. What is who necessary party, proper party is given, paragraph 18 of Supreme Court. It would thus be seen that necessary party is a person who ought to have been joined as a party and whose absence no effective decree could be passed at all by the court. It can thus be seen, or be held by the court, is that for the being necessary party. If the order is passed, ultimately,
18A.
if
If it is not, if it has.
it is,
not-
if it has been held, if necessary party is not impleted, suit itself is liable to be dismissed. It can thus be seen that what has been held by the courts, by this court, is that what being a necessary party, the two interests have been satisfied, etc. Then second one. Then paragraph 19, in the present case, alleged defamatory article was published in the that the publisher has not made a party, that is necessary party. Then order is passed. On periodic record, it seems the entire case of plaintiff rests on the new article, etc. I'm omitting that. See the order, my lord. Then next, can you turn the page, second line from the top? That apart, limitation apart, publisher was also not added as a party to the suit proceedings. And suit is not specific, namely attributing motive or malicious publication directed individually to any of the defendants and vague. Considering the entire facts, this court is inclined to allow the civil petition. Accordingly, civil petition allowed. Civil petition was for Order 7, Rule 11, rejection of plaintiff. Ordered 1, Rule 9 provides that no suit shall fail for non-joinder or misjoinder parties. But then there's proviso in that order is, this will not apply when a necessary party is not with a party. Can you see Ordered 1, Rule 9? Order 1, Rule 9. Misjoinder, non-joinder parties, no suit shall be defeated by means of misjoinder, non-joinder of parties. And the court may, in every suit, deal with the matter in controversy so far as that regards the rights of interest of parties actually before it. Provided that nothing in this rule shall apply to non-joinder of a necessary party. So Ordered 1, Rule 9 doesn't apply. Is not applicable when a necessary party, about which there cannot be any dispute. Look at the plain Miller only thing. Paragraph 14 of the paragraph. And can you see paragraph 1? That will make it clear. Paragraph 1. They know all the companies' names, parties, etc. Please come to page 52
of the running page 52 of our petition. The defendant number 1 is representing himself as authorized representative of companies, namely what traders, private limited, company traders, compassion traders. It goes on up to Lord Sena developers of 9A, Lord Sena Road, police station, etc. The plaintiff knew the names and address everything because in agreement for sale, these 30 companies are joined and parties as vendors, and their right, they have to transfer their appurtenant land right to the purchaser of flats, apartments. And yes, they have signed, they have parties exactly. Now, therefore, after this, can you see paragraph 14 at page 57? It said impugned agreement for sale without possession, this is absolutely void document and not binding upon the petitioner. Plaintiff. The impugned document for sale without possession, etc., suppressing the fact of pending with false declaration, etc. So we're asking for declaration, the agreement for sale is void without making the vendors of the said agreement, as paragraph 30 petitioners, is a party is there. Yes. And kindly after 14 read, kindly see paragraph 15, a portion of it. Names are given. Paragraph 15, kindly become similar. Plaintiff for the first time come to know on entertaining a certificate, copy of the impugned agreement for sale. He has obtained certificate copy impugned agreement for sale, etc. Input that agreement was made on 25th May 2017 by and between the said 30 companies. The names are all given.
Yes,
Those humble Miller, there's another point. Argue for trial court, illusory abuse process. Miller, I think Mr. Jointomit argue it better than me.
drafting, creating an illusion of cause of action.
So I think Mr. Jointomit argue it better than me, Miller.
এই জাজমেন্ট গুলো কোথায় রাখছো? ওই জাজমেন্ট গুলো দিচ্ছে আমি তো আর ফাইল বাড়ি নিয়ে যাইনি।
Please, your lordship.
স্টিচ করে রাখলে তো হবে না। না Did you give me other citations?
Yes, ma'am.
আরেকটা ফাইল আছে, এটা কোনটা?
6 analogous matters.
কোনটার মধ্যে রেখে রাখো, কোনটা শুনছি সেটার মধ্যে রাখো।
All are analogous matters, ma'am.
একসঙ্গে রাখো এগুলো, ফাইল করে জাজমেন্ট একটা আলাদা কভার ফাইল করে রাখো, তাই না? একসঙ্গে রাখো, একই তো। In 4 suits, same order has been passed, isn't it?
Yes.
No.
There are other files also, those are also appearing, all similar orders passed. Total 11 civil revisions have been filed.
Those 11 are where?
They are also appearing today, madam. Something added. Today is the matters of item number 73 to 77 and 79. The first one is 6 matters. Now they have filed other 5 matters.
তো এগুলো একসঙ্গে ট্যাগ করে দাও, একবারে হয়ে যাবে না? না, same order is challenged.
So order নামগুলো
Only suit numbers are different.
Suit numbers, party names are different.
No. But court passed only one order or different orders for different.
Different orders are different. Only the order number. The context of order will be different.
Contents.
Same operative was only paste and cut and paste.
Yes.
May it please your lordship. My lord,
এই ওই ফার্স্ট ফাইলটা যেটা দেখছিলাম ওটা দাও।
but I am making my submissions. Well, kindly excuse my.
Yes, Mr. Mitra, 1 minute. What is the date?
Day after tomorrow, by the fifth lower trial court.
Alright, ওটা কালকে রেখে দিও যেটা জিশু চৌধুরী মেনশন করলো।
Item number 159.
Yes, all right. Tomorrow, in the at the top, it will be appearing. Come tomorrow. Yes, Mr. Mitra.
My lord, I would request your lordship come straight away to the impugned order and judgment at page 277.
Yes.
At 277, lordship will be pleased to come to page 279. First 1, 2, 3, 4, 5, 6, 7, 8, 10th line. This is the only sentence we get in respect of section 34. Kindly come to page 279. Judgment starts at page 277 at page 279. Kindly come to 10 lines from the top. As regards. Has your lordship got that? As regards the other grounds for rejection of plaint as stated by the defendant, that whether the instant suit is barred under the proviso of section 34 of the Specific Relief Act or not, is also beyond the scope of Order 7 Rule 11. Stops there. Nothing more. No discussion, why not? But I just go straight away to assail this particular observation. I request your lordship to look into 1 or 2 judgments. But kindly take my lord 2012 8 Supreme Court cases, page 148.
এই দাও তো ফাইলটা, এই জাজমেন্ট গুলো দাও।
2012 8 Supreme Court cases, page
Page
148.
148.
Yes, ma'am.
যেটা এখানটা রাখো। Yes.
My lord, of this judgment, I request your lordship to come to page paragraph 55. This is a long judgment. In fact, my lord, Mr. S. Chauhan used to write very elaborate judgment, and this is one such. Paragraph 55, which should be at page 173 of this. Your lordship has got that? In view of the above, first of all, my lord, paragraph 55 is talking of section 34 and the proviso, and then citing certain decisions at paragraph 56. Then in 57, in view of the above, the law becomes crystal clear that it is not permissible to claim the relief of declaration without seeking consequential relief. In the instant case, the suit for declaration of title of ownership had been filed. Though the respondent number 1 plaintiff was admittedly not in possession of the suit property. I should show to your lordship that it is an admitted position that they were not in the suit. I shall show it from the plaintiff itself. In our case. Here also, the plaintiff was admittedly not in possession of the suit property. Thus, the suit was barred by the provisions of section 34 of the Specific Relief Act, and therefore ought to have been dismissed solely on this ground. So, my lord, I am first joining issue on this observation of the learned judge, one sentence which has got no backup at all by way of law, that as regards the other grounds for rejection of the plaint as stated by the defendant, that whether the instant suit is barred under provisions of section, the proviso to section 34 of the Specific Relief Act or not, is also beyond the scope of Order 7 Rule 11. This is a palpably ex facie, my lord, a wrong statement of the law. So my first submission is this, that the judgment cannot be sustained on this ground. When, my lord, the specific relief, my lord, specifically lack proviso to section 34 says otherwise. And then, my lord, this judgment also says that if the consequential reliefs have not been claimed, then it ought to be dismissed solely on this ground. Then, my lord, kindly come to this judgment, paragraph 85.12, where, my lord, the provisions have been, the propositions have been summarized. This was also a case on Order 41, Rule 27. I am not troubling your lordship with the earlier paragraphs. Kindly come to paragraph 85.12, which is at page 182. The suit was barred by the proviso of section 34 of the Specific Relief Act for the reason that the respondent number 1 plaintiff admittedly had not been in possession and did not ask for restoration of possession or any other consequential relief. That's my first decision I say. Second decision on this aspect of the matter, but this is not a stray observation, just to establish that. Kindly take 2017 3 Supreme Court cases 702. 2017 3 Supreme Court cases 702. Paragraphs 31 to 35.
Paragraph
31 to 35. Is one of the submissions. This is at page, this should be at page 710. One of the submissions made before the court below on behalf of the defendant was that the suit for mere declaration when the plaintiff was not in possession of the property was not maintainable and held by section 34 of the Specific Relief Act, the plaintiff having not sought for recovery of possession. The trial court, after considering the aforesaid submissions, recorded its conclusion in paragraph 14, which is to the following effect. Then, quote, from the facts of the above cited cited suit, the plaintiff in this suit has prayed for the relief of declaration without seeking the relief of recovery of possession. And under these circumstances, it is clearly seen that the plaintiff is not entitled to get such relief. Therefore, it is held the suit is not maintainable legally. Then section 34 has been set out in paragraph 33, then para 34. In the present case, the plaintiff having been found not to be in possession and having only sought for declaratory relief, the suit was clearly not maintainable and has been rightly dismissed by the trial court. In this context, reference is made to the judgment of the court in Ramsaran Ganga Devi. This is a leading case in para 35 at page 711. The plaintiff who was not in possession had in the suit claimed only declaratory relief along with mandatory injunction. The plaintiff being out of possession, the relief of recovery of possession was a further relief which ought to have been claimed by the plaintiff. The suit filed by the plaintiff for a mere declaration without the relief of recovery of possession was clearly not maintainable, and the trial court has rightly dismissed the suit. The High Court neither adverted to the above finding of the trial court nor has set aside the above reasoning given by the trial court for holding the suit as not maintainable. The High Court, in exercise of its jurisdiction under section 100 of the CPC, could not have reversed the decree of the courts below without holding that the above reasoning given by the courts below was legally unsustainable. We thus are of the view that the High Court committed error in decreeing the suit. High Court decreed the suit. The trial court said, no, the suit is not maintainable because you have not asked for possession. The High Court ignored that particular observation and my lord decreed the suit. Supreme Court, my lord, had turned it down. It said that you can't do that. My lord, on this aspect of the matter, Mr. Mitchell, my learned friend, has cited a decision of the Calcutta High Court. My lord, I just want to place 2 paragraphs of that which have not been placed. I am just placing it before your lordship.
Which is the citation?
My lord, this is that Calcutta High 2022 3 ICC 557. Well, this is a Manipatra citation. The Calcutta Landing and Shipping Company versus Manbasa Devi.
No, I'm not going. Yes.
The lordship has got that. Only 2 paragraphs I just want to. This is a quotation from the Supreme Court judgment. My lord, kindly come to para 14 of this judgment. This is the judgment of the learned single judge, which has been confirmed with the Supreme Court subsequently. Paragraph 14. The next issue falls for consideration is whether the suit is barred under Section 34 of the Specific Relief Act. Admittedly, the plaintiffs are not in possession of the suit property, but they omitted to seek the relief of possession. Whether such omission brings the suit within the mischief of the proviso appended to Section 34 of the Specific Relief Act needs to be looked into also. The failure of the plaintiffs to seek further relief of possession generally would not entail the dismissal of the suit without affording an opportunity to the plaintiffs to include the unsought relief, provided it is saved by limitation. In this context, it is opposite to court, paragraph 23 and 24 of 2014 Supreme Court cases. Para 23. The very purpose of proviso to Section 34 of the 1963 Act is to avoid the multiplicity of the proceedings and also the loss of revenue of court fees. Kindly note this both. This is, my lord, continuation of paragraph 14 with a quotation from the Supreme Court. Your lordship has got that, my lord? The very purpose of the proviso to Section 34, and this is what Supreme Court says, of the 1963 Act is to avoid the multiplicity of proceedings and also the loss of revenue of court fees. When the Specific Relief Act 1877 was in force, the 9th report of the Law Commission of India 1958 had suggested certain amendments to the proviso, according to which the plaintiff could seek declaratory relief without seeking any consequential relief, if he sought the permission of the court to make the subsequent claim in another suit or proceeding. However, such an amendment was not accepted. There is no provision analogous to such suggestion in 1963 Act. Then, para 24. A mere declaratory decree remains non-executable in most cases generally. However, there is no prohibition upon a party from seeking an amendment in the plaint to include the unsought relief, provided that it is saved by limitation. However, it is obligatory on the part of the defendant to raise the issue at the earliest. We have raised the issue at the earliest. So, my lord, if you do not get claim possession, then you should ask for possession. If you do not ask for possession, then, my lord, the suit is liable to be dismissed, my lord, under Order 7, Rule 11. My lord, now I am, and then, my lord, your lordship will be pleased to see the Supreme Court has said in this case, in respect of this matter, only one paragraph order, your lordship has seen that. There, in as much as it says that we do not find any error in the judgment, in as much as the perusal of the prayer clause in the suit would reveal that the prayer is only made for declaration without any consequential relief. So, my lord, this is really substantiating this. As such, the suit as filed was not maintainable. Now, my lord, I am on this. Your lordship may ask me, how do you say that he was not in possession? So that, my lord, it is compulsory on his part to ask for possession. The plaint itself shows that he is not in possession. This is, my lord, a tricky plaint. If a suit has been filed on trickery, my subsequent submission will be it is an abuse of the process of court. But now I submit to your lordship that look at the plaint itself. It will appear from the plaint itself that, my lord, he was not in possession. My lord, what has not been told to your lordship is that he has already filed a suit, an earlier suit, suit number 663. There, my lord, he claimed exactly the same relief, decree for declaration. That suit is pending. Keeping that suit pending, another suit has been filed for the same declaration. Why? I ask this question, why? Why is it one suit pending? Why the same suit? Your lordship will please to come to that particular title suit. This has been referred to in the plaint. Therefore, I am in a position to, my lord, draw your lordship's attention to it. Kindly, my lord, see the plaint, the present plaint. Your lordship knows, my lord, under Order 7, Rule 11, your lordship is only to look into the plaint itself and the amendment made there. Nothing more, nothing less. And, my lord, it has been said that what is referred to in the plaint or annexed to the plaint are also, my lord, can be looked into. My lord, plaint in the instant case at page 51. In page 51, kindly come to paragraph 2. The plaintiff on 4th May 2018 has filed a civil suit being title suit number 663 of 2018 before the learned civil judge, First Court Junior Division, Alipur, praying what? One, that by dint of deed of sale dated 25th June 1999, the plaintiff purchases, etc. He has said, my lord, the averments. I shall come to the averments afterwards. Kindly come to the prayer that since the defendant number one, it is III at page 53. Since the defendant number one continuously disturbing the peaceful possession, the plaintiff has filed the said suit on the following prayer. Kindly see the first prayer. For a declaration that the plaintiff is the sole, absolute, and something owner, 16 annus owner of the suit property, fully described in the schedule herein. This prayer is the same prayer as my lord prayer A in the instant petition. My lord, this suit has been filed. I would have expected, I am telling you, Lordship, my lord, I would have expected that when the defendant, or rather the plaintiff, found that he is sought to be dispossessed, then what should he have done? Amended the plaint, impleaded the defendants, all of the defendants in one suit, seek, my lord, the prayer for possession. Declaration is already there. I am seeking possession. I am telling you, Lordship, why he should have sought possession, because he himself is saying he is out of possession. How he is saying so? Kindly, my lord, come to paragraph.
But he can still do it.
My lord,
He can still do it.
if he can do it, my lord, he has not done it.
Because
This suit cannot be.
section 34 will, the judgments that you have placed, those were the suits were decreed like that.
Right.
Ignoring the prohibition under section 30. But it is also settled that by way of an amendment, a prayer for recovery of possession can be.
Yes, of course it can be.
Even the non-joinder of parties can be cured.
Yes.
So these are all curable defects.
No, but
So
then
for
again,
that reason, the court did not reject the plaint as a whole.
no. But my lord, what I am submitting to your lordship is this. If your lordship finds that he is deliberately not asking for possession, why? In order to save court fees. Why is, my lord, I ask this question to myself.
Fails.
Then the suit should fail. And this is exactly what I said in Rule 11.
Opportunity first has to be given to him.
Opportunity.
Or he can avail of.
Yes, my lord, it is not a question of, my lord, I am pointing out to you that you amend your
But
plaint.
now the court has stayed the proceedings.
Yes, but then again, my lord,
Where will you ask? Suit has been stayed.
my lord, kindly see this. It's not a question. Your lordship kindly takes the plaint once. My lord, kindly come back to the plaint, page 53. Kindly come to page 54. Paragraph 6.
Yes.
My lord, paragraph 5 says in the title suit, they made an application. And my lord, an order was obtained by them. We came before your lordship, and your lordship was pleased to pass an order. That has been annexed, my lord, by your lordship, dated 9th March 2021. That has been stated in paragraph 5. I'm not troubling your lordship for the time being. Kindly come to para 6. Kindly come to para 6. He has himself admitted in the plaint that he is not in possession. The plaintiff states and submits the defendant number 1 in the said revision application has also admitted the following facts. 1. The petitioner herein has been impleaded as the defendant number 1 in the said title suit number 663. That in connection with the title suit number so and so, the said Upendranath Banerjee has filed an application on order 39 rule 1. 3. The petitioner being the sole defendant, that is my client, in the said title suit number 663 of 2018 is a director of National Towers, etc. Then 4. All these properties have been acquired by the 30 companies by 52 registered deeds of conveyance between the year 2010 and 2011. The plaintiff knows all that. Then our next paragraph. A building plan was sanctioned in the names of the said 30 companies on 9th October 2018. Then, my lord, subparagraph 6, booking has been received from about 175 numbers of flats for all the 4 towers, of which there are 14 numbers of registered agreements already there. Next subparagraph, the plaintiff, through their learned advocate, by letter dated 20th December 2019 had addressed to the said 30 companies inter alia called upon them to abide by the order of injunction. The title of the said 30 companies flow from Satish Chandra Pramani. In the said title suit number so and so, an application for amendment was filed by the plaintiff's hearing. Then, my lord, kindly see, come to paragraph 14 of this whole, he knows everything. And he has stated himself, 4 towers, 40 owners. And then, my lord, kindly see para 14. That the said impugned agreement for sale without possession dated 24/12/2021, being deed number so and so as set forth in Schedule B here below, is absolutely void document. I shall come to it why he is saying void. Not binding upon the plaintiff. The said impugned agreement for sale without possession dated so and so, being deed number so and so, has been prepared by suppressing the fact of pending litigation, section 52. He is pleading that, with false declaration as regards right title interest. Next paragraph. It is to be mentioned that at the time of institution of the suit, being title suit number 89 of 1997, no construction stood on the land in dispute. Namely, 10 bighas of land in Moza Madurdha, comprising of RS Dag number 455, left by Satish Chandra Pramani. The defendant number 2 made construction on alleged authority of 30 companies during the pendency of the suit, prejudicing the rights of the plaintiff. Well, as I say that it's a clear admission that he was not in possession. Construction has been made on his land, he says. Now, then I fail to understand that how can he get relief, any of the reliefs in the plaint, without asking for possession? And he will not ask for possession. Why? Because it's a tricky suit. If I ask for possession, I will have to pay the court fees. 2 katas of owner of 2 katas of land. Why should he pay court fees? So I file 140 suits. I don't pay court fees. It's an abuse of the process of court. It's a clearly an abuse of the process of court. The court, my lord, doesn't entertain that kind of a stand. My lord, it has fallen from your lordship. I didn't answer that question at that time. Why is it that he cannot put in the, make the...
Pray for amendment.
Pray for amendment. He will not pray for amendment. If he had prayed for amendment, he would have included those prayers in this plaint itself. He has deliberately not done it for the simple reason that if he does it, then he will have to pay the court fees. But here is a clear admission that he has been dispossessed. He is saying defendant number 2 made construction on the alleged authority of 30 companies. And before that, he has given details of 4 towers, so many registered documents, building plan, everything.
In the earlier suit, is there any injunction?
There was, I shall come to it. There was an order of injunction. My lord, we came up before your lordship was pleased to modify the injunction, allowing us to construct. I showed you, lordship.
It's a pollution. So for my knowledge goes.
All right, we'll see that.
I shall immediately come to it. Now, my lord, along with this paragraph in the plaint, lordship will kindly come to prayer number 3. Here also it is admitted. In the prayer itself, he has admitted. Prayer 3 of the plaint at page 60.
Yes, not to hand over.
Yes, it says permanent injunction restraining is a very, I must say, the ingenuity of the learned draftsman. I congratulate him. But he has drafted in such a way so that he will give an illusion of a cause of action when there is none. And this is exactly what has been condemned by Mr. Krishna Iyer in that case of Aravindam, which has been followed subsequently. I shall just draw your attention. Permanent injunction restraining the defendants, their men and agents, servants, or any person on their behalf from interfering in the plaintiff's Schedule A property over which Schedule B property is created. What is, I don't understand. It's simple English. I have got a Schedule A property of which I am asking for a declaration. On Schedule A property, Schedule B property as construction. has been-
Probably B is the construction. What is B?
Yes, ma'am. They will kindly come to B, what is B? Kindly come to page 61. All that residential flat apartment bearing number so and so at page 61. And in
We
100,
are dealing with which CO?
well, I'm dealing with
796, 769.
আমি জানি না ভাই এটা কি 991 CO number. Well, your lordship, is there any difference in page number?
Yes, yes.
I see. It should be after the paragraphs of the plaint, the prayers have been set out. Kindly come to the prayer. I don't
The
mention
prayers I have seen.
same prayer, absolutely same prayer. Schedule B is after the prayers. Kindly
This
see.
is 663 of 2018 suit.
Yes.
Suit number 663.
No. That is the earlier suit. To
Where
which
is this suit?
this suit is at the top, page 51 or 53, whatever it is.
191.
Yes, yes. 51.
This is the suit in which he has referred to.
332. 332.
Yes, ma'am. Well, in this suit, he has referred to sections the 663 suit. So I am emboldened to show to your lordship the plaint in the other suit also. Otherwise, I would have been confined myself to the plaint itself. Plaint is itself not only referring to 663, it is quoting from that particular suit. And in that, my lord, in that paragraph, the plaintiff himself is saying that if there are 4 towers constructed, conveyances executed, building plan sanctioned on the basis of which this has been done. So, my lord, I say this plaint is based upon dispossession. If it is a plaint based on dispossession, then the plaint should have contained a prayer for possession. I am submitting to your lordship that in spite of the fact it was pointed out to this, and this was specifically taken, making this as a ground in my application under Order 7 Rule 11, that the suit should be dismissed because, my lord, the consequent relief has not been asked for. In spite of it, my lord, they have not done it. And they have continued to file, my lord, suit. I don't know how many suits have been filed. 106.
All the 106 you filed Order 7 Rule 11.
Yes, yes.
106 orders have been passed.
No, not all of them, only in 11.
No.
All are fine.
In all of them, Order 7 Rule 11 application has been filed, and 11 suit, the order has been made.
Teacher.
But in this also not, section of the order have more than 100. In respect of each suit, 1 application. But in respect of each 106 suit, application made. His lordship is hard, 14 one matter, and we say the same, therefore same judgment. 11 matters.
11
are to be.
matters.
The list of the suit they filed is already there, and it keeps happening. List of the suit they filed. List of suit they filed is also there.
Yes, anything else?
Yes.
Mr. Mitro?
Well,
In answer to my
জিজ্ঞেস করলেন যে
আমি আসছি।
page 202 with the Gita.
এটা আমি আসছি, আমি ওটাতে আসছিলাম, আমার এখানে রয়েছে লিস্ট।
শেষ করে নিয়ে বলে না party at no time miss হয়ে গেছে।
Right. Well, now, before I come to this segment, your lordship will you please to take, my lord. Yeah.
The list of suits at page 202 of this petition. They have all discussed there.
So all these suits are there. Now, my lord, kindly, my lord, take one note of one thing. Kindly come to page 191 of this brief. Maybe, my lord, one or two
I'll
pages.
find out.
The title suit number 663. It's
Yes,
a part
yes.
of the plaint. And there, my lord, kindly see the prayers are at page 195. Well, I think, I do not know whether your lordship can read what is contained in that, because it's absolutely smudged. The plain, copy of the plain, can you not read it?
Which suit?
That's page, this is suit number, title suit number 663, and earlier suit,
Yes. It's there with me.
but then again, my lord, can you lordship read it?
Yes,
Or-
I can. read. 663 of 18.
Yes, 666, the file, another suit filed, earlier suit filed by them. There, my lord, the first prayer at internal page 5 of that plain, declaration that plaintiff is the sole and absolutely same prayer as it is in, my lord, the suit in respect of which, my lord, we are moving this application. And permanent injunction seeking the evidence restraining from peaceful possession. Normally in this suit, they obtain, my lord, police help order. My lord, in this, my lord, only Manish Sharma has been made party. The other my lord, companies have not been made parties. Now, my lord, kindly see in that suit, your lordship was pleased to ask me this question: what order was passed? This matter, my lord, came up before your lordship. Kindly come to the page 237, or it can be, my lord, 239 or 234, 240. This is your lordship's order. I think it is necessary for me to read it so that your lordship can understand or remember really. Page 237, or
Yes, I've got it.
you have got it. Second paragraph, the petitioner is agreed by the order dated January 27, 2020. By the order impugned, the learned court below allowed an application under section 151 of the Code of Civil Procedure by which the prayer for police help for implementation of the order of ad interim injunction was allowed. Mr. Mitra Abhrujit Mitra, learned senior advocate appearing on behalf of the petitioner, submits that the order of injunction was restricted to defendant number 1. The said defendant was restrained from creating any disturbance to the plaintiff's peaceful possession and enjoyment of the suit property. According to Mr. Mitra, being emboldened by the order of the learned judge, court below, the opposite party plaintiff along with the police personnel are trying to interrupt the ongoing construction being carried on in the adjoining plot of land. Well, this order is of March 2021, 2 years earlier. Interrupt the ongoing construction being carried on in the adjoining plots of land, namely the premises number 761 Madhurdaw. I have considered the plaint and I find the suit property is recorded as a bill, but in the nature of the agricultural land and measured around 2 cutters, 8 shuttacks, 24 square feet. I have considered the order of injunction from which I find that defendant number 1 was restrained from creating any disturbance in the plaintiff's peaceful possession of the suit premises by an interim order. For implementation of such application for police help was filed on the allegation that the defendant number 1 was trying to stack building materials over the suit plot, which was required for ongoing construction. So, my lord, at that point of time, my lord, question of possession had come in. Prima facie, I find that there was no injunction with regard to construction work, but the defendant number 1, who happens to be a director of some companies who are carrying on construction work, was restrained from interfering with the peaceful possession of the plaintiff. Thus, in my prima facie view, there would be no occasion for the police to interfere with the construction, save and except if it is found that the construction has been in any way interfered with the plaintiff's enjoyment of the suit property. Prima facie, the application under section 151 of the Code of Civil Procedure does not contain any such averment. Being satisfied with the prima facie case of the petitioner, it is directed that the police shall have no authority to interfere with the construction of the premises at number 761 Madhurdaw. But the order of police help shall be restricted to ensure that the property is not encroached upon by the defendant number 1 or his men or agents in any manner whatsoever. So, my lord, the construction has gone on thereafter. They filed this order was passed in 2021. March. They did not file the suit until recently when, my lord, they my lord junior points out at page 245, after this order, if lordship's copy, it will be 245. It is ordered in 26th November. Kindly, my lord, take that order. I do not know. Is it at page 242? Or 245?
No, some other, I've got it. The second,
45.
next order.
Yes, 245. Next order. The allegation of the petitioner is that the petitioner has title by purchase over a portion of the premises in question, and the name of the petitioner has been mutated in the records of the corporation. The petitioner is also an assessee and pays the property tax. It is submitted that in view of the aforementioned facts, the Kolkata Municipal Corporation could not have given sanction in respect of the building to be built over 10 bighas of land by the respondent number 6 to 35. The disputed premises are Schedule A at page 12 of the petition, which is set out hereunder. Then, my lord, it has been set out. The petitioner claims to have purchased some of the lands from the heirs of the erstwhile owner out of the aforementioned land. Mr. Mittal, learned senior advocate, appearing on behalf of the respondent number 6 to 35, relies on a document issued by the Kolkata Municipal Corporation dated November 16, 2021, which shows that premise number 761 in respect of a sanction has been granted, did not have any nexus with premises number 1877, over which the petitioner claims right title and interest. So, my lord, either, my lord, kindly see, either, my lord, the petitioner is in possession or is not in possession. If he is not in possession, then, my lord, there is no question of, my lord, obtaining an order of injunction against me. And if we are in possession of his land, then he has to claim possession. Either way, my lord, the suit is defective. And I have submitted to your lordship that, and your lordship is pleased to see that judgment, that if your intention of avoiding the provisions of proviso to section 34 for the purpose of avoiding court fees, revenue, then the suit is bad. That is what, my lord, quoted in the judgment of Mr. Vishwajit Basu. My lord, our land is in premises number 761 Madhuddha Road, Kolkata, and they have themselves annexed that at page 139. That's the deed of the deed. So, my lord, I respectfully submit to your lordship that this particular application should be sustained, and, my lord, the order should be passed as paid for. Apart from it, my lord, I'm sorry, I forgot one thing. My lord, apart from it is a question of abuse of the process of court. On this, my lord, I will only cite before your lordship 2 or 3 judgments. Kindly, my lord, take 2006, 3 Supreme Court cases, page 521. Sorry, 100.
Page?
100.
Yes.
2006, 3 Supreme Court cases. Lordship, kindly give me 1 second. No, copy আছে? Judge copy আছে? Oh, দিয়ে দিছি। But only 1 paragraph. Lordship will be pleased to come to straight away. Kindly give me 1 second. I've lost my copy amongst this bundle of papers. কোন প্যারাগ্রাফটা বলতো? Kindly give me 1 second. 2023 SCC online data. Well, kindly take, well,
15.
2023 SCC online, well, para 15.
6 places.
D'accord, continue.
2000.
Prevent abuse of process of.
You can still lay down the, in the required the necessary preventive. Well, for the time being, kindly leave it. 2023 SCC online, Supreme Court, 521. Kindly take para 28 of this. Well, para 28 says this. Well, kindly take 27 first. In the case of Ram Singh versus Gram Panchayat Mehal Kalan, reported in 1986 four Supreme Court cases, this court observed and held that when the suit is barred by any law, the plaintiff cannot be allowed to circumvent that provision by means of clever drafting so as to avoid mention of those circumstances by which the suit is barred by law of limitation. Similar view has been expressed by this court in the case of Rajnarayan Sarin. That was a case of barred by law of limitation. Applying the law laid down by this court in the aforesaid decisions on the applicability of Order 7 Rule 11 to the facts of the case on hand, we are of the opinion that the plaint ought to have been rejected in exercise of power under Order 7 Rule 11A and B of the CPC, being vexatious, illusory cause of action, and barred by limitation. By clever drafting and not asking any relief with respect to partition deed dated 11/3/1953, the plaintiffs have tried to circumvent the provisions of Limitation Act and have tried to maintain a suit which is nothing but an abuse of the process of the court and the law. And my lord, this was what was found. And my lord, the last decision on this subject is, my lord, another Supreme Court decision reported in 2021, two Indian civil cases. এগুলো কপি দাও other side কে কারণ পাবে না হ্যাঁ page 15. Only 3 paragraphs I would like to refer your lordship to. Paragraph 7, 8 and 7, 8, 5 আছে. Very well. 5, 7, 8 and 11. 5, 7, 8 and 12. 5 is, it is well settled that while considering an application under Order 7 Rule 11 of the CPC, the question before the court is whether the plaint discloses any cause of action or whether the suit is barred by any law on the face of the averments contained in the plaint itself. While considering an application under Order 7 Rule 11 of the CPC, the court is not to look into strength or weakness of the case of the plaintiff or the defense raised by the defendant. Then 7. In any case, an application under Order 7 Rule 11 of the CPC for rejection of the plaint requires a meaningful reading of the plaint as a whole. Para 7. As held by the court in ITC was a Debt Recovery Tribunal, Appellate Tribunal, reported in AIN 1998 Supreme Court 634, clever drafting creating illusions of cause of action are not permitted in law, and a clear right to sue should be shown in the plaint. Similarly, the court must see that the bar in law of the suit is not camouflaged by devious and clever drafting of the plaint. And my lord, I am adopting this as a part of my submission. Moreover, the provisions of Order 7 Rule 11 are not exhaustive, and the courts has inherent power to see that frivolous or vexatious litigations are not allowed to consume the time of the court. Then it says, in this case, a meaningful reading of the plaint as a whole makes it abundantly clear that the relief claimed in the suit is barred in view of the restricted scope of power of attorney given with the first defendant. Then, my lord, para 12. It is patently clear from a meaningful reading of the plaint in its entirety that the plaintiff has no cause of action against the first defendant, being the owner of the suit property. The power of attorney being patently invalid, the interstate dispute between the heirs of the deceased defendant will not confer any right on the petitioner as the claim. Well, this is on the facts of that particular case. Therefore, my lord, I am submitting to your lordship that having stated in the plaint itself that he is not in possession, he should have claimed possession. But it is not a case, my lord, that there was any controversy with regard to possession. There is no dispute with regard to that. That he is not in possession, he himself is saying in paragraph 12, and my lord, the prayer in the plain, prayer 3. Therefore, that being the position, my lord, possession is an essentiality. And after it was pointed out, when the defendant is saying, is my lord insisting on not, my lord, amending the plaint, or my lord, including the prayer for possession, then my lord, suit is liable to be dismissed.
This is
Well,
Vasu's judgment.
No, there is just one Supreme Court judgment, my lord, on this issue, what is fallen from your lordship. This is, my lord, reported in AIR 2022 Supreme Court, page 471. Para 19. I just place it before lordship and I conclude my submission. As already discussed here in above, the plaintiff himself has admitted in the plaint that the suit property is jointly owned by the defendant, his wife, and 3 sons. A specific objection was also taken by the defendant in his written statement with regard to the non-joinder of the necessary parties. Since the suit property was jointly owned by the defendant along with his wife and 3 sons, an effective decree could not have been passed affecting the rights of the defendant's wife and 3 sons without impeding them. Even in spite of the defendant taking an objection in that regard, the plaintiff has chosen not to impede the defendant's wife and 3 sons as party defendant. In so far as the reliance basis so and so, I am not troubling your lordship. So, my lord, if then in para 20, in the conclusion, it can thus be seen that what has been held by this court is that for being a necessary party, the twin test has to be satisfied. The first one is that there must be a right to some relief against such party in respect of the controversies involved in the proceeding. The second one is that no effective decree can be passed in the absence of such party. In view of the plaintiff's own admission that the suit property was jointly owned by the defendant, his wife and 3 sons, no effective decree could have been passed in their absence. Therefore, my lord, this judgment I am relying upon on the 2 points, both on the not for asking possession, that is my primary point, and secondly, my lord, not impeding, as Mr. Mitra has submitted, not impeding the other defendants as parties here. In spite of the fact they knew about it, they have themselves shown, my lord, who are the other persons who are the owners of the property. So, my lord, not having impeded them, my lord, suit is bad. And my lord, after we have taken the objection, he is insisting on proceeding with the suit. This, my lord, perhaps is not permissible in law. But these are my respectful submissions.
Mr. Vasu will continue. We'll take it up next day.
Yes.
Next day.
Mr.
Rai, how long will you take?
I don't know about Mr. Basu. After Basu, I'll take.
Because only point of law.
Yes, sir.
What you should do, how you have drafted your plaint, what you should do to continue the suit.
The points I have to.
The court has said all the defects which they have pointed out are remediable. So at that stage, it cannot be
Yes,
rejected.
So I'll just.
Now you have to say whether.
Basically, their entire case relied upon the question of possession. So I have to submit your lordship at the stage of orders and 11 that can be, because they refer to relied upon the judgments which are regarding decree, not orders and 11. That I place it.
No, that is okay.
Mr. Basu will complete them.
3 issues: non-joinder, undervaluation.
Okay, take it tomorrow.
Section 34.
and section 34. এই এটা একটুখানি ওকে বলো তো নিচে, আচ্ছা আমি উঠে যাই, তারপরে দুটো জাজমেন্ট পড়ে গেছে।
But they're not covering it. Just 5 minutes something.
15 minutes. So it's a 5 minute giants are really.
So I have other matters. Anyway, your suit is stayed. You're not suffering anything. এগুলো include করে দাও. Yes.
I was keeping it on.
Let this matter appear along with item numbers. এই সবগুলোর মধ্যে সিও করে ঢুকিয়ে দাও। এই যে এখন তো অলরেডি তিনটে চারটে একসঙ্গেই হচ্ছে, তার সঙ্গে এগুলো অ্যাড হয়ে যাবে।
The 6 matters now.
হ্যাঁ, আজকের অর্ডারে এগুলো অ্যাড করছো।
When you fix it.
Our concern is state, but then this is deterring the buyers. They are cancelling it just because of this. 4 agreements have got cancelled. That's their aim.
এই সময় পকেট পালিয়ে গেল, খাতাটা দেখো। 26 তারিখ দেখো।
26.
সাতাশ, তো ইয়ে দিন, কন্টেন্ট থাকে। First August, second fix করা, 2 PM 2nd August.
2nd August.
Yes, call the 3 PM matter কেউ আছে?
Second
Matter which was fixed at 3
2nd August.
PM?
I cannot do matter. 2nd August. But then again, I'll go there. Come back today.
I can't fix it like that, Mr. Rai.
I understood.
Let Mr. Basu finish. Mr. Mitra also has to finish.
I am insignificant. Well, I have 5-7 minutes.
10 minutes, 15
Maximum.
minutes. Mr. Amrjit Mitra also wants to submit, so half an hour. You come back on the next day. Yes, all right.
ঠিক আছে, I'll come back today. I'll come back.
So you come, they can finish. If that day I'll post it another day. Let them finish. At least the matter can
ফিনিশ
proceed.
করে নিন, তারপর তুমি বলো
Yes, sir.
সব গুছিয়ে।
And then I'll come back.
হ্যাঁ, সব গুছিয়ে।
Mr. Mitra, you don't want to add anything?
No, man, I don't. I have concluded.
Yes. আমি আজকে এসেছি।
I have
ওখানে
concluded.
বলো যে ওখানে লিখো Mr. Ananda Kumar Mitra, Learned Senior Advocate, concludes his submissions. Mr. Joyanta Kumar Mitra, Learned Senior Advocate, also concludes his submissions. Let this matter appear on 2nd August at 2 PM. For further consideration, along with OCO. সবগুলো একসঙ্গে থাক।
Well, grateful to you.
Yes.
Conclude my submissions and lost my voice.
Yes, 3 PM matter.
3 PM fixed it.
3 PM 96 na, thanks.
Walk up bell. Madam, you open the bit, kindly look to the walk up.
We are for the opposite party number 3.
Kindly come to appear on behalf of the Bob board.
এই এখানে যেটা পড়ে গেছে ওটা কিন্তু তুলে ওখানে রেখো।
Kindly come to section 54.
Walk of Act, this is the old act, is it amended?
It will suffice.
No, how can it suffice?
I will show the annotation is there in the bottom of the old act to my wicket. This is amended.
No, the Walk of Act was amended recently, no?
That I would not necessary for our. Well, kindly take one fact. Since my lord 1948, we are in possession of this property. Now kindly read section 54. Whenever the chief executive officer considers whether on receiving any complaint or on his own motion that there has been any encroachment on any land, building, space or other property which is Waqf property and which has been registered as such under this act,
he shall cause to be served upon the enclosure a notice specifying the particulars of the encroachment and calling upon him to so cause before a date so specified in such notice as to why an order requiring him to remove the encroachment before the date so specified should not be made, and shall also send a copy of such notice to the concerned Mutwali. Can I pause there for a moment? Here is the contemplation of a notice to be served. Is there? Because 50 would itself prescribe that. Without serving any notice, my lord, an order has been passed.
By whom?
By the executive officer. Order was passed on, date is relevant, 21st November 2003. Now, my lord, kindly come to in the bottom, the subsection 4 had been amended. So, pre-amended portion is required to be seen because on that date, it was amended subsequently of 2013. So, pre-amended section is applicable to us. Probably in the bottom, I will get that. Now, subsection 4, prior to substitution, nothing contained in subsection 3 shall prevent any person agreed by the other made by the chief executive officer under the subsection from instituting a suit in a tribunal to establish that he has right, title, and interest in the land, building, space, or other property. So, I was subject to suit. I can proceed against the order of pass under section 54 in a suit. That has been amended on 2013. Now, the question is, under which provision I am governed? My order is pre-amended section. I file a suit. Now, they have said, the order impugned said, suit is not maintainable. Then what should I go? This is my precise question to my lord and me.
What is in the amended?
Amendment suit, power of suit has been taken up. Now, for 4, rewrite as the tribunal upon receipt of such application from the chief executive officer for the recorded therein make an order of eviction directing the work of property shall be vacated all persons who are, this is the power. This power under subsection 3 has no more there. So this is the order pre-amended. So I am subjected to pre-amended subsection 3. The suit is maintainable. This is my lord, the case before my suit has been dismissed.
What is the order of eviction?
Kindly come to the order in full.
Not the impugned order, order of eviction. That encroacher declaring you as no
order there. Eviction order is not annexed, my lord, that is with me. Because ex party, then my lord, while the time of execution, we got it and we obtain a copy.
This suit will not necessarily shall prevent a person constituting a suit in a tribunal. So, work of tribunal, suit before the tribunal
Yes,
has to be.
yes. The nomenclature is suit there also, not application. I'll keep on that. This is the plain copy of the order. Yes. This is an ex parte order.
2003.
This is an ex parte order. We obtained it, my lord. We came to learn when they sought to evict us. We applied under right to information. I got this order and we filed a suit.
Cost of 50,000.
50,000 cost imposed.
No, but is it rejected on merits or on your not maintainable?
Maintainable. Not maintainable under the law, and the same is dismissed.
Order 14 rule 2. Preliminary issues were framed.
You want to rely on any decision?
Statute is clear. It is not the prospective amendment. It is not a retrospective amendment. Prospective amendment.
You have Act 27 of 2013. The amending Act, Act
This is one of-
27 of 2013.
My lord, get it here at the bottom.
Come into effect from?
It is effect from, my lord, September 2013.
1/11/2013.
November.
Where did you get that?
1st November.
That must be লেখা আছে।
Affected.
প্রথমেই লেখা।
No, it has come into effect from on 20th September. The act came into existence.
Where did you find it?
Where, Lord? This is at the top, first page. Works Amendment Act 2013, Act 27 of.
First page of the book. And the bottom, my lord, will find
Just after the contents.
23rd September 2013.
Then
Lordship,
you are for?
I am for the
Opposite party number 3. Muthuwal.
I am for the
Please
board.
for the board.
Want to evict us? No, I don't.
You are for?
I am for the board of Lordship, kindly look into the application at running page 76, paragraph number 14. Uh, 76, paragraph number 14. The plaintiff petitioner number 1, Biswajit Bhaumik, by his letter addressing to the Chief Executive Officer, Board of WAF, West Bengal, submitted in the office of the Board of WAF, West Bengal on 16/12/2002, categorically denied all allegations regarding encroachment as labeled against him, and he further stated that there is no masjid in plot number.
These are factual aspects.
Now, what my learned senior friend was harping upon, that it was an ex-party order. So this goes on to show that it was not ex-party.
it is not
He
an ex-parte
participated.
order.
Now, the pertinent question is, in the earlier act, there was a provision for filing a suit. Thereafter, after the amending act, there is no such provision for filing a suit. Now, it is not having a retrospective effect, rather it is having a prospective effect. This is the question of law, what is before your lord. And my lord, one more thing what I'm harping upon, there was always an opportunity for them to file a suit.
But Mr. Basu, subsection 4, unamended subsection 4 is an independent right given to any person who wants to claim right, title and interest. You want to claim your independent right at the point when you are disturbed.
So prior to that, there is no occasion.
So why will the unamended portion apply?
Because when the
Because
order was passed.
it is not, no, is subsection for a continuation of the proceeding for of the
Lordship.
Board of Work. It is not.
That
It
I'm
is
saying.
not.
The order has been passed against me.
Today an order is passed against
me.
you.
I have a right.
Notwithstanding that, you had a right pre-amendment to file a suit,
Right.
asserting
I've
your
done
right,
that.
title and interest.
I have done that.
But at a time when that provision was not there.
Lordship.
So if you study,
So it cannot be, cannot be remediless.
no, there must be
No
something.
remedy that I've checked up.
Why?
No remedy.
No,
Kindly see. He had
you can ask for declaration
No, suit I cannot
that
file.
your 83.
Suit I cannot file.
83(2).
Subsection 2, Lordship.
Yes.
This order will stand.
Let it stand, you'll miss the bus.
That will stand.
You go to a read court and ask for setting aside on the under violation of natural justice. Nothing else. You have enough remedy.
No, no, that is there. But so far as
No.
3 is concerned, multiple
No.
notice can look to it. 3.
4 is an independent provision which allows any person who asserts his right, title, interest to do so
What is about 3?
irrespective of an order of removal of encroachment or not.
What is about 3? 3 accrued a right in favor of a person against whom order has been passed. By accrued right can be taken away by amendment. I'm asking the question to myself. 2003 order has been passed. On that date, I have a right to appeal, file a suit.
No. You had a right to file a suit up to September or August
Lordship.
2020, 2013, irrespective of whether the Section
I told
54
myself,
was invoked or not.
I had a right.
Your right to file the suit under 4 is not subject to an order passed in Sep 54.
Yes. Can you once again, can you allow me to?
Go file a suit in 82-2 and let it be heard.
82.
82.
Tribunal.
54-3. Order has been passed in 2003
Hmm.
when I had a right under 3. You challenge the order.
Where is that? 54?
54-3. Pre-amended. For subsection 4 prior to subsection of subsection 4.
It is a saving. Because 82-2 was not there, a right was given to you also to assert your title in a particular forum. Now there is an independent section by which you can file a suit and pray for declaration of your right, title, and interest before the tribunal. 54-4, before amendment, it was not an appeal.
For the time being, don't think that 82 can forget from time. Kindly come to 3 and 4. Nothing contained in subsection 3 shall prevent any person to agree by the order made by the chief executive officer. So this is the order passed by chief executive officer. On that date, when the order was passed, I had a right to challenge that.
Yes, by 226.
No, under 3. Under 3. Under 3. Under 4. Pre-amended 4.
Achha, okay. No, wait,
Yes.
let us see.
Allow me to read.
If after considering the objections,
No.
3.
3. I am not on 3. I mean amended. Pre-amended 3.
Pre-amended 3 or pre-amended 4?
Nothing contained in subsection 3
Hmm.
shall prevent any person agreed by the order made by the chief executive officer under that subsection from instituting a suit in a tribunal to establish that he has right title interest in the land, building, space, or other property. That would have had. Then, if my lord, the interpretation my lord is giving, if that be so, then nomenclature is nothing. The suit is maintainable.
Yes.
This suit is also mentionable under 282.
82. 82-2.
2.
Yes.
Under 82-2, my lord, it has to be an application, not a suit.
That can be what's the difference?
There must be a
Encroachment
remedy.
on any such work of property, he may
I don't
make
mind
an
to
application
what
to
I
the
have filed is a
tribunal
suit.
for grant of an order of eviction for removing such encroachment and deliver possession soon. In this case, was 3 invoked by the board? Subsection 3? No.
Lordship, definitely. Yes.
You went to the tribunal.
Lordship.
For
No.
execution.
Did you
For
go to the
execution,
tribunal?
yes.
Yes, all right.
There I came to learn that is the order.
No, he participated. You participated in the proceedings.
that is okay.
Yes, execution. Execution proceeding. You participated.
Amended act.
Amended act to নতুন
82 কোথায়?
নতুনটা আছে এই তো নতুনটা 83-2 লর্ডশিপ আমি দিয়ে দিতে পারি
Lord, 83-2, leave aside the first part, the disjunctive or any other person. Kindly read from or any other person.
Yes.
And the prescribed time limit is Rule 26, 30 days.
30
for
days.
date of order.
Now,
which he has chosen to go given a go by.
Now, can you see the fallacy?
That 2003 order which
Order.
Justice Mr. Basu
Now,
just
see the
now-
fallacy.
Can't be 2003 order. If you are saying that he can't avail of the remedy under the unamended act,
Yes.
then the date of the order cannot proceed from there.
No.
Where is rule 26? Show me.
Rule 26.
নতুন
Milord,
বইটা
নতুন বইটা আনো নি?
না নতুন
So rule 26 in the amended act and unamended act, Milord, are the same. Referring from the old book.
Question.
rule 26 টা আছে পূর্ণ বইও আছে
Milord, the prescription, that is the time limit,
1 minute.
is in rule 26.
দেখি
Kindly read rule 26. That is the prescribed limitation. They are circumventing the provision.
from the date of knowledge
Yes. Filing the suit after 17 years.
17 it is just an afterthought, nothing else, because all the provisions have been exhausted. নামটা কি আছে? নামটা কি? ভুলের নামটা কি?
West Bengal law rules 2001, এটা পাবেন।
এই ধরনের আলাদা একটা
মোটামুটি।
Where is that order? Show me that they participated.
lordship, it is an admitted fact.
Yes.
Page 77, your lordship may kindly find it out. Page 76 rather, paragraph 14, they have admitted it.
No, that is in 2022.
It was way back in 2003 because
It is their government that they were aware of this in 2003.
Para 15.
Para 15
Page 76.
as a plaintiff petitioner during submission of the said letter. They met with the defendant opposite party CEO and made oral submissions. Lordship, on the other hand,
You know, not only that, under the unamended 54(5) before the magistrate, they have participated.
participate
That order they
thereafter.
have given. 54(5), the order was supposed to be put before
And
the
it is-
magistrate for
it is-
execution.
54 what was the limitation then?
30 days
30 days, Lordship.
or suit, if the suit was available to them. No limitation, suit was available to
No
them.
limitation.
No limitation.
But the right has been taken away by the amendment.
Amending Act.
And Justice Torun Chatterjee, late lamented Justice Torun Chatterjee's judgment in the Supreme Court, my lord, the act is not retrospective. 2008, volume 9, SCC 306.
Again, in the government, they are stating that SPO.
Then how can you go back?
Prospective.
How can you go back in
prospective,
2020
That
to file a suit?
cannot be taken away.
You cannot file a suit after 19 years by circumventing the provision of 83(2). Any order has been passed by the CEO. If you are aggrieved, you could have filed a
Filed it,
83(2) application with section 5 or section of the Limitation Act.
I am saying that the unamended 54 did not have any limitation prescribed.
No. but the right to suit has been taken away.
By
Now
the
this
amending.
is- Now,
By
yes,
the- by the amending.
there has to be central active challenge the virus.
Prospective, I say. My submission. I said it's prospective. So if it is prospective,
Milord, it's not
whatever right I have accrued
No,
in the pre-amended act cannot be taken away by the amendment. Accrued right cannot be taken.
Your accrued right was there all through.
Yes, to file a suit, but it is
And
not known to us.
till
After
the section was alive.
No,
Lordship.
this is my.
Irrespective whether
am joining
54
issue
was, one
I am-
was there or not,
I am joining issue here for the simple reason that I have accrued a right.
or fails to comply with the order of eviction in 45 days from the date of amendment, the executive.
They have executed the order after 15 years.
Duly authorized by him.
no, you participated in
Lordship,
2005.
2005 also he participated
Your own annexure.
before the SDM. Yeah, annexure.
Your own
Yeah,
annexure.
averment.
Page 38, page 38.
This is the
But
application.
Mr. Basu, now you have averred that you were there and you knew.
Lordship.
The order I don't knew.
Kindly have a look at the
Order.
judgment of Justice Challenge.
Lordship,
It is
if
not known to me. The
Kindly
order.
have a look at the judgment, paragraph 40.
All judgment time.
T. Kalyamurthy, 2008, volume 9, SCC 306. Elaborate judgment, sitting with
What does
Justice
it
Ashok Kumar
say?
Mathur.
What does it say?
Now kindly have a look at paragraph 40. So far as the retrospective of the act.
No, that is accepted. Nobody's, he's also.
No, no,
not very
he is saying that suit is available now also. That can't be.
No, I say
That can't
challenging
be.
that order, suit is available.
No, he is saying suit is available because
that
that
order.
order was passed under 54(1) when the unamended part was there.
Yes.
Lordship take.
Now, because the 54(1) was in 2003, 54(4) was there. Basu, 54(4) is a appeal or a remedy given to him by the law, being if he is aggrieved by a decision under 54(1). The issue here would be whether 54(4) is dependent on 54(1) or it is a separate remedy available, notwithstanding whatever happens in 54(1).
Right.
Which is against Mr. Basu.
Yes, it's a separate.
That I'm
It
submitting.
is a remedy.
Whatever right has accrued and I'm
No
challenging
right
an order.
accrued to you, the right accrued
I am challenging an
from the
order.
day the act came into force and remained till 2013.
13,
That
Lordship.
cannot be incorporated.
Irrespective of whether 54(1) was used by them or not. Even if there is an encroachment order, you can file a suit. Even if it is not there, you can file a suit if there is a dispute.
And
with
HCC
regard
2 is there.
83
And
two
now-
there.
Any order.
Any order.
This appeal as 83 too.
No, cannot be.
It cannot be.
Subject to limitation.
Subject will
Right, 226.
For that, my lord, I have to file
You know,
this.
only remedy as Philip from your lordship is 226.
কোনো নেই, ওই
সবসময় চিরকালের জন্য চলে যাবে নাকি?
Kindly have a look at the date of cause of action and the first
And
prayer.
2000
Whether at all, kindly see the cause of action of the suit, date,
সুটের তোমার সুট।
হ্যাঁ
and kindly see the first prayer. Then I'll say something.
এ,
Then kindly see the first prayer. Declaration that he is the absolute owner.
2003.
Kindly
and
kindly see
Running.
prayer.
2009.
ongoing.
And kindly see prayer A.
Because of the no
So
limitation
if
under
he
the
says, it is his own property, then Article 65 will be governed 12 years. Then also gone. It is not work. 107 will not apply. Limitation, no limitation. If
Cannot.
property is claimed, he is claiming personal property.
Whenever I was disturbed, then my accrued, right accrued.
Disturb.
Before
Cannot
that,
be
I would not.
2005 you
When they want to
participated.
execute.
2005 we
went-
participated before the magistrate.
You wrote a letter to the board.
Yes.
You
Board.
went for a hearing.
Hearing.
You went
Thereafter,
to the SDM and contested the eviction proceeding,
my lord,
and you did not know.
any order passed, not to me, no. My case is
Thereafter,
order was not known to me.
Government.
So
Then
you
this
will
judge-
not-
Government.
You
Government
feel there was a
never.
disturbance to your protection.
Not disturbance was not affected then.
Lordship in,
Disturbance was not affected then.
and in the averment
Basu,
also.
You have to convince me that 54(1) is not an independent, 54(4) is not independent of 54(1). That is the only point here.
But by I kindly may I reiterate what are my submission? My submission is
তাহলে আর আসতে চায় না মানে মামলা করা।
And the main blunder they have committed, Milord,
Submit-
subject to
submit.
correction, they challenge the order of Milord, enforcement of the order, execution. And withdrew.
Your condition is
My
when the original order was an
I'm challenging the original order of 2003. I am challenging the order of 2003.
not in a suit.
That is the previous provision.
No,
I can file a suit.
no, you can file a suit not to challenge that order.
I can also.
Irrespective of an order, you can challenge a suit to decide your dispute
yes.
or assert your right.
This order
No. This is
54 Kali wants read that pre-amended section.
আমার পরের দিন পড়বো 26 কত পড়বো আর সকাল থেকে 10:30 থেকে তো পড়েই যাচ্ছে তার আগে ভোরবেলা থেকে
May I take back the book and give a copy? May I take back the book and give a copy? That judgment.
There's no
তোমার
time.
আউটমেন্ট দেখো আর একটা কি করেছে
Para 40.
লাগবে না। You have to come with, if you have an authority that 54(4) is not an appellate provision of 54(1), it is an independent provision. Mr. Basu has to prove otherwise. You know what I'm saying is correct.
Yes, I can understand.
Concede, I'll dispose of.
Then I heard what my client will go.
I will record it, all your clients' unhappiness. But why has the period of order law of limitation been prescribed? To bring a finality to any
But again, I am.
And lost
you
up to
cannot
magistrate
be, you cannot be remediless, but you have to avail of your remedy within reasonable time.
I'm lost.
That's why. my lord,
Lost
I
up to magistrate court, thereafter OA 6 or 18.
This act, section 5 applies.
Yes. That is there is no provision. That is only rule 26 says that within 30
days.
Section 5.
There are rulings as
Judgment of
well.
Justice Dipankar Datta.
Ruling is there that after 140
Yes.
কতদিন 300 দিন ছিল না
2012 volume 2 Calcutta Law Times.
days limitation has been
Ghulam Mustafa Haidari versus Shahid Sheikh.
বুঝতে বলে যাচ্ছি।
Section 14 will apply.
হ্যাঁ
তুমি যাও ওকিলকে বুঝিয়ে টুঝিয়ে আরেফিন কে বুঝিয়ে দাও ফিটা নিয়ে concede on the next day. Mr. Basu, you know that what I'm saying is correct.
I appreciate but fact I cannot develop. Council cannot develop the fact.
So I will give you liberty if to and you can raise that
No,
point
but
of proceeding in another
That is
forum.
14. If I have the availability of limitation act, then 14 will squarely apply. That is no problem.
Bring that judgment.
I try me.
আমাকে
That
ফোন করে দিয়ে দিন
54 4 and 54 1.
54 হ্যাঁ
No, that limitation is there.
That judgment of Justice Dipankar Datta.
হ্যাঁ
Yes.
দীপক দত্ত
Exactly. When law decide না করে, it can you're out on facts also. So that if that applies, then you go and get it re-agitated.
হ্যাঁ আবার
It is not known to.
কবে রাখবো?
Next week কোথায় যাবো? তোমাদের পাড়ায় যাচ্ছি।
এই 3 তারিখে রেখে দাও.
Subject to
When
my
are you going?
My lord's পাড়া।
And the circuit bench is, when is it, this is the first?
I'm going tomorrow.
Oh, tomorrow.
সেকেন্ড আছে সেকেন্ড
Why don't একদিন রেখে দাও এই পকেট
আর বেশিক্ষণ না 3:30 বা 4
Friday.
আমার মনে হয় বেটার না এই সেই গ্যাঞ্জামের
To
মধ্যে
be mentioned. Bring everything and I will finish it.
আমাকে
then.
দিয়ে দিস আমি দেখে নেবো তাহলে
হ্যাঁ হ্যাঁ
morning
কিছু করতে হবে না।
Yes.
He is
no
Nah, this
Listen
is
that
not
walk up,
August.
so
4th August.
4th August.
he is
Wait, let me check.
Oh,
he is
acha,
session
acha, acha.
walk up
No.
tribunal. That's why it's difficult for him to come in the morning.
He is?
Session that walk up
tribunal to get stationed.
My lord, I'm not hearing him. Is everything in his
Achha,
fingertips? All judgment.
When can you come? What time is available?
All Sojira Subita.
Would it be because only the judgment
2
at 4
PM I can't.
4
No,
4
I have
3:30
original side.
at 4 oh, no
On Fridays, I have original side after 2. So
For the
you have to
first-
come before that.
then at 10:30
হ্যাঁ ঠিক আছে 10:30
yes I have to come. My lord directs me I have to.
Come at 1 o'clock.
Yes
হ্যাঁ সপ্তাহে
যে আমাকে আগে দিয়ে দিবি subject to যে আমাকে আগে দিয়ে
no, those expeditious disposal matters are there.
Respective
ঠিক আছে ভাই।
parties, let this
হ্যাঁ?
matter
Judgment
be
আমি-
resolved. The 4th August, sorry, at 1 PM.
the great
আমার লাঞ্চ টাইমটা খাবে আর কি তোমরা।
না নেবো না না, if
Expeditious
find-
disposal matters are there.
no, as my lord knows, if I find my lord I can consider
আমার নামটা কোথায় দিলি দিদি
but this
You have to.
limitation point is not in my mind.
ফেলে দিয়েছি বলে
You have to. Side applies because I have
That I have to check.
the other earlier rounds I have dealt with rejection of section 5.
Oh, then if it is applies, no problem.
I have allowed, I condoned the delay. I remember.
No problem. Then it is no problem. Then other unnecessary.
That fact that this is like a plane and it is not a, it is has the trappings of a suit.
Suit.
So it is.
Section 5 not applies.
Not been,
It is an
applied,
application.
At least till now in a walk-up.
Because it is sued, that's why I was thinking that it may not apply.
That's what they said, no, it's a application.
Let the judgment be, I don't know.
The same analysis of section
26.
might be used.
Yes.
Because it's a fresh proceeding.
Yes, possible.
But in any event, that has not been used.
That is there, my lord, I will buy.
And section 5 has been made applicable, normally tribunal.
And
has
some
made,
observation from my lord and I will,
which I have allowed.
no problem.
Unknowingly. ওদিকে তাকিয়ে বসে।
উঠবে তো কি করবে তো টাকা দিয়ে দাও
এখানে judgment পড়ে গেছে, একটা তুলে রেখে দিও কিন্তু ওই মামলাটা। Yes, all right. Then on the 4th.
Yes.